लिस्ट दिखिए दी पहले urgent matters. These will appear.
My Lordship, I'm for the respondent number 3 and 6. I'm led by Mr. Banerjee, praying for a short passover, my Lord.
Who is appearing for the petitioner? This was mentioned for non-prosecution and then nobody is appearing.
No, respondent. Petitioner claim.
This mentioned, लिखे दिन तो this matter क्यों नहीं? This matter is appearing under the heading to be mentioned.
Beg to appear on behalf of the state.
लिखे नहीं, none appears for the petitioner. Full stop. The petitioner remained unrepresented even on November 27, 2025. Full stop. It appears that the petitioner is not interested in pursuing its cause.
But item 3, my lord.
Huh?
Item 3, my lord.
Yes.
My lord, I'm praying for my lord, short passover, my lord.
Why?
Learned senior is busy in another court, my lord. Kindly short passover, my lord. Short passover.
Passover করে
My
দাও।
lord.
Four, my lord. 4, 5, 6, 7, my lord. Similar, my lord. My lord, here, my lord, I am challenging, my lord, 67 GST Act, my lord, search seizure, my lord. 2, 3 grounds, my lord. Number 1, my lord, that 67(1) is the inspection. Prior to that, reason to believe. Then 67(2), if inspection not carried, then also otherwise, the otherwise is the term there. I will show your lordship. This is omnibus term. But there also, reason to believe must be prior to search. Here, my lord, reason to believe not recorded in the Panchanama, INS 01, also not recorded by the report submitted by my learned senior friend. Second, my lord, if I pass in the reason to believe, then everything goes. If I fail in the reason to believe, then my lord 6710 comes. What 6710 says? 6710 not is a complete code, relied on the criminal procedure code. Now the BNSS. Said, so here, my lord, the relevant law of section of BNSS said that at the time of search seizure, there must be present of 2 independent witness from the local, respectable person from the locality. Because my lord, to maintain the credibility and the search procedure in the transparent manner. And my lord, also the video recording of the entire search procedure, because that will create, that may create adverse situation against me. So video recording. Now, there are CBDT instruction 2021. The CBDT instruction, I will show your lordship, attached in the writ petition, that they are also said that reason to believe must be recorded, and the video recording and the witness. Here, my lord, in my case, no reason to believe recorded, number 1. Secondly, my lord, that independent witness not brought. The employee, my employee, there are 4 set of firm. First one is our private limited. Second one is my lord partnership firm of the petitioner number 2. Third, my lord, the proprietorship concern of the petitioner number 2. Fourth item is my lord, the petitioner number 2's wife. So the officers came more or less 10 to 20 minutes gap, different set of teams in all the places same times, more or less. That, my lord, independent witness, they made the employee. Employee cannot be the independent witness, nor, my lord, in the Panchanama, it is recorded they have tried to bring the independent witness from the locality. It is not recorded. And also no effort recorded to record the entire procedure in the video camera, my lord. It is not recorded. Also, my lord, in the Panchanama, in the office premises,
Videography is
mandatory as per criminal procedural code, my lord, because
Yeah,
6710 relied on the criminal code, my lord. I will show your lordship. Thereafter, my lord, in the Panchanama, they recorded in the residential premises, come office premises, they recorded that no incriminating material found, 24 lakh cash found. Now, another question come. Cash cannot be seized under the GST law because cash is a money. Money falls under the definition of section 2 within bracket, perhaps 57, 75. What item can be seized? It is seized. It is mentioned in 67(2). That is books, goods, etc. I will show your lordship. So, Honorable Supreme Court also held that no, cash cannot be seized by the GST authority. Next, my lord, that in the Panchanama, it is written that we have scrutinized the books of accounts. So, if they scrutinize the books of accounts, then it must be recorded in the Panchanama that what is the cash balance as per books of accounts? Not recorded. So, my cash balance recorded in the books of accounts, and I have in the writ petition, I have explained that 13 lakhs is for my petitioner number first file. They say 3 lakhs for second file, 5 lakhs written accordingly. I will show your lordship. Next, my lord, in the factory premises, they have mentioned no incriminating material, only 2 gate entry register receipt. Gate entry register cannot be the proof of the incriminating material, and also reason to believe not recorded prior to cess. And here also made the employees the Panchanama 1, Panchanama Pancha 2. But in the factory premises, while searching, we have supplied the stock statement. They verified, but they did not verify
Show me
properly.
first where is the jurisdictional error so that I can interpret.
Yes. My lord, first is 67, 67(1), man.
One demurrer which I will be raising, Lordship may for once turns to page 57.
157.
Well, only 57.
Only 57.
Only 57.
আমি স্যার শেষ করে নিই তাহলে
Page
No,
57 is the affidavit.
Yes, my lord. My lord, your Lordship will kindly see, I, Hemadri Shekhar Pal, my lord, the writ petitioner over here is the Pushpa Furniture Private Limited. So-and-so residing at so-and-so, I am the employee and constituted attorney of the petitioners to affirm the instant writ petition on behalf of the petitioners. I am duly authorized and well acquainted with the facts of the case. But all the incriminating allegations which have been leveled are saying that it is true to his knowledge and humble submissions. Therefore, making various serious allegations with regard to the manner of investigation and the search and seizure operation, nobody is taking responsibility of the statements which have been made before my lord. In all the 3 writ petitions, it has been affirmed by the power of attorney holder by the applicant concerned.
No, but if the power of attorney holder has true knowledge of the situation, then in
Malad, that
case
it has to say that it cannot
he
be
says true to his knowledge.
true to his knowledge. Malad, true to his knowledge means that he is affected party.
No, true to his knowledge means he knows.
Malad, how does he know? He has to disclose that. How
that
does he?
that will be a different thing, but he has
Malad,
he has-
personal knowledge.
in the affidavit he has to disclose the source. He has disclosed the source as his
Malad, true
knowledge.
to his knowledge by a power of attorney holder has to be in conformity that he is an employee.
No,
he
not
discloses.
necessarily. Anybody who has knowledge can affirm it as true to KK Nambiar's case. I think KK Nambiar is true to knowledge will be a person who knows about it.
Who knows about it and
a
was
cons-
present,
a
or
cons-
he is way.
A constituted attorney can be a witness or can give evidence.
My lord, that is,
Can give evidence to the extent the constituted attorney knows.
yes, my lord.
If he does not know, then in that case his evidence will not
Yes,
be
my lord.
considered.
I
Here
am
in
deeply
this case, he
obliged, but
says-
over here, that statement is specifically mentioned.
No, he says it is true to my knowledge.
My lord, how the knowledge has come to him, because he is a
That
part
is
of.
a different question. How it has come to may be a question of probe. But on the basis of his having said that it is true to his knowledge, the affidavit does not become.
My lord, the power of attorney holder wants who files an
erroneous.
affidavit, because he says over here in the paragraphs, because over here the various factual in the various paragraph factual allegations or factual materials have been averred. Kindly see, my lord, it has to be taken seriously. A power of attorney holder cannot just simply say that it is true to his knowledge.
No,
But
if it is true to his knowledge, why can't he say, Mr. Banerjee? If
Yes,
it is
my lord.
true to his knowledge,
my lord, he has to say that I was present, that he has been present at the time of search and seizure.
that he can always explain upon being called upon. But if he had not disclosed whether how it is, what is the source of the information, then
Always,
in
my
that
lord,
case,
it has to be disclosed. Otherwise, the power of
so this information source has been disclosed as knowledge. It has to be records of the office, or it has to be knowledge. Now it is true to his knowledge. We can call upon him to explain how it is true to his knowledge.
Yes,
that
sir.
he can definitely explain by way of a supplementary affidavit. If it is not true to his knowledge, then in that case
it has to
cannot
be
there.
shown in what way he is acquainted with the facts of the case.
He was also present at the time of search.
Because he says I am the employee.
Yes, my lord.
He is an employee. So if he is an employee and he was present, then that can be true to his
My lord,
knowledge.
that is not mentioned in the affidavit.
If he is no, that can always be if he says that he is an employee and it is true to his knowledge. The affidavit is not that perfunctory that on the basis of this writ petition
Lord.
can be said to be.
Now, my lord, I'm my lord, referring to section 67, my lord.
Section 67.
In one word, my lord, is this search and seizure is complete harassment to honest taxpayer. My lord. I will say, submit your loss. I will show your loss.
67.
67, my lord. May I, my lord, read?
Yes.
My lord. Here, my lord, the chapter is inspection, search, seizure, and arrest. Section 67.
What are your points one by one?
Yes, yes.
On
This is
section
my point is, my lord, 62, because 67(2) is there, says that reason to believe may become two types of, my lord.
according to you, there are no reasons to believe.
No
So this is
reasons to
point,
believe. This is
point
very
number one.
important.
Let me
Yes.
formulate your point so that it is easier. Because
Yes, 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 yes.
we will go all around the world
Yes, yes.
without the point.
Reasons to believe, my
Number
lord.
one,
And this is
reasons
not
to believe are
recorded.
not there.
Not recorded in the INS 01, INS 0.
No, there is a difference. Reasons to believe are not there, or reasons to believe are not recorded. Which one?
My lord,
If
prima
there
facie.
are reasons to believe and they have not been recorded, that is one thing.
Yes, yes.
If
Prima
there are
facie,
no reasons to believe at all, that is a different
lord,
thing. What
my-
does the section say?
my lord,
They have to be there or they have to be recorded. They say that they have to be there.
My
It
lord,
says which,
and 67(2), my lord. The
yes,
proper
or
officer
otherwise has reasons to believe.
believe.
So reasons to believe should be there.
But
It is not
instruction
that-
says, yes, instruction says,
Which instruction?
yeah, page number, my lord, 144 of the read petition, my lord.
Page 144.
Yes, my lord. 144, my lord. Serial number 2, Roman 1. This is the important instructions, my lord, binding
Yes,
on them,
yes,
my lord.
yes.
The 67(2), my lord, such and such, such and such, such and such. Thus, the following guidelines must be adhered to while carrying out such proceedings. The officer using authorization for search should have valid and justifiable reason for authorizing a search, which shall be duly recorded in the file.
In the file.
File. Now,
File
my
will
lord,
not be with you.
not with me,
So-
but my lord, at
So
the
this reason they have to record in the file.
But that
is
must
for the
be-
internal
that must
satisfaction
be-
of the officer concerned,
yes,
not
disclose,
for your.
must be disclosed before your lordship.
That they will disclose.
But
But
in
they
the
will
report,
bring
my
the
lord, it
file.
is not disclosed. In the
My lord,
report,
Report they are not required to tell you.
not
In
record, my lord,
report,
but before your
if it
lordship,
is challenged, yes, definitely they will.
before your lordship, because I have, this is my vital point in the, my lord, affidavit. Kindly see, my lord, their report, page, my lord, para 24, once, my lord,
Para 24.
para 24, my lord, their report, my lord.
Where is the report? I don't have any report.
Report then
Report টা দিয়ে দেন। ওরকম paragraph এ লিখে
আমরা দেখছি, দেখো তো রিট পিটিশনে প্রথমটা কত নম্বর প্যারাতে আছে।
The চারটে না, একটা একটা
একটা,
give
প্রথম-
one at a time. Don't
Nine-
give your bunch at the same
19155 প্যারা 24
দিদি এইটা একটু লিখে নেবেন তো, নালে ভুলে যাব। রিপোর্ট ইন দি ফর্ম অফ অ্যাফিডেভিট filed on behalf of the respondent numbers 5 to 8 is taken on record. নালে এটা আবার মাঝখানে ধুয়ে যাবে, ভুলে যাবে।
Your Lordship knows, my lord, that Income Tax Act section 132, their explanation clearly says that reason to believe should not be disclosed before the authority or tribunal, but it should be Honorable Delhi High Court and Apex Court held that the reason to believe should be before the Honorable High Court. I am carrying that judgment, my lord. Para 24, my lord, I am drawing kind attention, my lord, Your Lordship. Your Lordship got, my lord, para 24, my lord. The search of business premises such and such were carried out based on reliable evidence, credible material, available on record, and commodity.
Page
Page, my lord, 7 of the report, para 24. WPA 19155.
yes,
My lord, searches at the business premises of such and such were carried out based on reliable evidence, credible material on record, and commodity being the evasion prone. Commodity being the evasion prone, this is assumptive language, and the evidence is record. Where I am challenging in the writ petition, this is vital point, that must be disclosed before your lordship. It is not disclosed and not recorded in the INS 01. And Allahabad High Court, my lord, for non-recording the INS reason to
what is
believe.
INS 01?
INS 01 is that, my lord, page. They, in the report, my lord, at the time of search, my lord, they showed, because this is the first document, page 9 of the report. INS 01 not supplied at that time. Later in the report they attach, my lord. Page 9, my lord. But here also, reason to believe not recorded. Allahabad High Court was the for recording, non-recording of reason to believe. This is very vital, my lord. And your lordship knows, my lord, this is controlling provision. This is controlling provision. This is the intrusive power, my lord. The legislature has consciously ring-fenced this intrusive power by inserting controlling provision,
Yes.
my lord. This is very important. If I pass this point, then everything goes, my lord. Now, my lord, I am drawing your lordship kind attention in the Panchanama, my lord. First Panchanama. First Panchanama at page, my lord, that the office cum resident, page 62 of the writ petition, my lord.
Page
62 of the writ petition.
62.
62, my lord.
Yes.
Third para, my lord. I mean, this search started 12:45 AM in the first para, and I am reading from third para, my lord. First, second, third. On the ground floor. May I read,
Yes.
my lord?
Yes.
There is a reception counter used at administrative work, which is two computer, such and such. The officer were searching the incriminating document from the both side of the parts of the premise. The counter of the office, some incriminating documents relating to the evasion and GST business related record were recovered. All such incriminating documents issuing the order of seizure in GST INS attached. I'm showing, madam. Next para. After that, the officer searched the residential premises. In the ground floor, my lord, office. In the first floor, second floor, my lord, the resident. So, such and such. No any incriminating documents are recovered related with the evasion of GST and business related. However, one of the Almira second floor owner's room, 24 lakhs found kept, the same been seized as per provision of the that amount seized and handed over to my lord in the drawer of the petitioner number 2 and sealed, my lord. Then, my lord, I am drawing, my lord, your lordship kind attention, page number 64. INS 02. INS 02, my lord, order of seizure. My lord, I am second para, my lord, on scrutiny. Your lordship got, my lord, on scrutiny. On scrutiny of the books of accounts, registered documents paper, I have reason to believe that 2 number handwritten exercise book are lying in the mentioned above. And, my lord, in the latter part they have written handwritten Annexure B, my lord, serial number B, Miraka exercise book, 2 notes, and my lord, Indian currency 24 lakhs, and right side written, my lord, that this amount recovered and the transactional receipt currency and considering the same evidence supply without any bill or invoice. But my lord, it is not recorded what amount cash balance as per books of accounts. It should be recorded. This is a vital my lord such procedure. It ought to have record that what amount of the cash balance as per books of accounts. And also in the Panchanama, it is not recorded that there are no bill in the accounts. Whereas in the right side, they have mentioned that no bill invoice. Next, my lord, that these register, my lord, are the check entry register. They have seized. After seized, my lord, I prayed for documents that was not supplied. So this check entry register, my lord, cannot be the proof of the incriminating material. This is the point. Next, my lord, I am drawing, my lord, your lordship, the factory premises, page 67. My lord, in the first, my lord, that Priyotos Das, Subhadra Chandra Mandal, they are the employee, and I also missed, my lord, in the previous, also in the Panchanama first, my lord, that two names mentioned.
Page
67. They are the employee, my lord. Page 67. 67, my lord. My lord, got my lord, third para. Third para, my lord. So here, my lord, the name mentioned in the upper portion, that Pancha 1, Pancha 2, they are the
67, yes.
67. They are the, my lord, the witness made. In the first Panchanama also, that I missed to mention that they are the employee. Here also they are the employee. So, my lord, I am starting from third para, my lord. At the time, may I read, my lord? At the time of the visit, one individual present in the premises, namely Sri such and such Borman, identified himself, technical staff of such and such, Sri Dharmesh Borman carefully perused the same, acknowledged the receipt, affixing such and such, such and such. That's, my lord, I am, my lord, next, my lord, 68, my lord. 68, second para, my lord. May I read, my lord? 68, second para.
Yes.
During the such proceedings, Sri Taposh Pal, looking after the business activities of the factory, arrived and assisted the team of the officers. Such proceedings, on being asked about the stock, sales, supplied, related documents, it was stated by Pal that such documents are maintained at the office premises at Devinagar. That was the office cum residence. This is the factory, Kalibari. And regarding these activities, such and such, they received the order from the office over phone. Subsequently, the staff checked the availability of stock and confirmed from the office. Then, my lord, I am next para, my lord. The officers then contacted with the counterpart team conducting search officer. The
What
Pushpa
is
fund.
the point, Mr. Rai?
Yes, my lord.
What
The
is the
point is that, my lord,
My lord, may I
that
just
annexure
interrupt?
one. No. I mean,
Just interrupt, my lord. While the matter was taken at the admission stage, my lord, in courtroom number 5, there are two issues which have been involved, for which the court directed us to file a report. One is the cash. The cash was the main concern of the court while there was an argument before the court. Over here, with regard to the jurisdiction as to whether the GST authorities, in spite of legal stipulations, have attached or seized the cash. To that effect, we were required to file our report. With regard to the merits of the proceedings, this show cause, search and seizure and other things, it was the oral observation that it can be decided at a later point of time. But our endeavor was before my lord with regard to the cash seizure, which he submits, that it is against the legal stipulation. Now, with regard to the merits, whether the search and seizure is legal, valid, or illegal, well, he is absconding because he is not answering to the summons which have been issued in connection
No,
with
but
the.
he has raised a point that reasons to believe should be there. Now, reasons to believe, even I don't agree with him that it has to be recorded anywhere, because that is not the mandate of the statute. But reasons to believe must be there in the file.
Yes, my lord.
Now, once you say file a report saying that you had reasons to believe, what are those reasons?
Well, that is in a, kindly see the averments in the pleadings of the petitioner. Well, to such an extent my lord, the averments have been made to 1 to 19 are only the two to his knowledge, and the rest are his submissions. Now, so far as we could scrutinize, we could not find that there is specific averment to that effect within the 19 paragraphs that there is no reasons to believe. Only the case was with regard to the jurisdiction of the search and seizure and the cash seizure. Now, with regard to that, well, we will bring the record. We have the reasons to believe. Otherwise, these are all the statutory mandate, without which no search or nothing can be done.
Not Delhi High Court and Supreme Court have confirmed that. I will show you the last sheet.
Show me that. Show
Yes,
me that.
yes,
Because
yes.
instead of
My
going,
lord,
reading
this para is important, my lord, only this para, my lord. This.
please drive at the point. Unnecessarily, we'll be wasting
Yes.
time.
Here, my lord, I'm saying. Reasons to believe, my lord, very important.
He cannot make up the case at the
And
time of
also,
his argument.
in this case, my lord, that Panchanama signature not obtained. Here, my lord, page 68, 69. That is I'm trying to show, my lord. And they have verified. Kindly see the 69 page, my lord. The Panchanama. No signature obtained. And, my lord, this short of span of time, entire stock of the factory, my lord, cannot be verified 5-6 hours, my lord. It will take, my lord, 3 days time, my lord. And kindly see the page 70, my lord, also. No signature of the witness. Only employee's signature taken. Though these employees are the witness are the employee. This is very important, my lord. My lord, I am showing, my lord. May I show the judgment of, my lord, Delhi High Court that are Honorable Apex Court also. Supreme Court, my lord, the first 2 pages of Honorable Apex Court, my lord, and para 9.3, my lord, of the Delhi High Court judgment, my lord. May I read, my lord? Start from 9, but operative 9.3. This is GST context.
9.3.
9.3. Para 9 to 16. Nine to 16. But may I start from 9.3?
I'll read.
My lord. After 9.3, lordship may jump to para 12. 12, 13 onwards. 12 onwards.
Where is your letter of authorization, Mr. Banerjee?
INS 01.
There.
Yes, that is there in the report, my lord. INS 01. That is letter of authorization.
That one.
But they are also reason to believe not recorded, nor recorded in the Panchanama, nor supplied before your lordship to the report.
Then this becomes vulnerable, Mr. Banerjee, in the light of the judgment of the Delhi High Court. Please notice,
Lordship is referring to
you see paragraph
9.
paragraph 9.5.
Okay.
9.5 and 9.6.
yes, my lord. Over here, my lord, from the pleadings, I do not find is I am not able to get where he has made such pleadings to that effect regarding reasons
No,
to
but
believe.
upon this being disclosed, the letter of authorization.
Yes, my lord,
being
that
disclosed-
it is there in the file. My lord, I have to bring the entire file. My only report was concentrated with regard to
authorization court was looking upon the authorization only.
Well,
That is why I said paragraph 9.5 is the authorization.
yes, my lord. My lord, I shall have to check the original records because our report is restricted with regard to the cash seizure and the manner
What is
in
your
which-
submission about the cash?
my lord, cash seizure.
I am also carrying judgment, my lord. I am sorry, lords.
My lord, let me also refer to the judgments with regard to the search and seizure, my lord.
My lord, definition, my lord, 275, my lord. The 67.2, my lord. First, my lord, kindly have a look. 67.2, my lord. Sorry.
67 I have read.
They are seized goods, documents, books, but money falls under 2, subsection
It is a
75.
judgment of it.
Cash cannot be seized under the GST Act.
My lord, over here, my lord, this is the settled principles of law. My lord, kindly refer to 2024 11 SCC 372.
Sir, to copy the now.
Read it. My lord, I am referring to paragraphs 36,
Narcotic, NDPS.
36, my lord, where
The GST law.
regards are very strict, apart more than the GST law. My lord, 36, page 20 to 21.
My lord, my little understanding, NDPS Act not applicable in
36.
Yes,
para 36, sir.
para 36.
Yes.
Malad, Malad, it is the common proposition of law. Malad, I would just like to enunciate. Apart from Malad, he was arguing that the search and seizure is totally illegal. To that extent, Malad, I am referring to this judgment, para 41, 43, 47, and 48. Malad, kindly note before your lordship, Malad, at your lordship's Malad kind convenience, Malad, kindly go through the
41,
41, 43,
43.
47, 48, and para 50.5.
47,
48 and para 50.5.
48, para 50.5.
Yes.
This is said procedural illegality. That is
Now
not
over
procedural.
here, also, my lord, I am also referring to another judgment of the Supreme Court that is regarding the income tax. Malad, over here, your lordship knows, Malad, para 39, 2022 16 SCC 139. Copy. Malad, the nature of the reasons to believe. What manner, Malad, it has to be interpreted?
কত নম্বর প্যারা বললেন স্যার?
Para 39.
39. 39. 39.
It has to be reasonable nexus.
Yes, but there should be reasons to be.
Yes, Malad, it should be there.
There
I-
should be reasons to be.
I'm
I need
also
to bring, Malad, let him.
I'm
first-
also carrying.
Malad, let him first bring the averments in the writ petition. Malad,
Where are your averments that
kindly
the-
see that there is
there
no
are no
reason
reasons
to
to
believe.
believe?
Kindly make him that. I cannot find it. Malad, if he can correct me, I shall be grateful.
My lord, that I'm checking, my lord. Just praying a moment, my lord. দেখো দেখো reasons to believe.
এখানে ওই এটা down, হ্যাঁ?
পেজটা খোলো।
Malad, I'm also
60,
referring-
67 2 not followed. That is, my lord, mentioned in the averment. 67 2, my lord,
paragraph,
reasons.
Malad, let me see the paragraph.
The
Malad,
first I have seen from grounds, but I am
taking us
also.
for a ride since inception. Malad, we are trying.
I have searched from the, but I am from the.
Malad, it cannot be there. Malad, it is a court of record, and we are bound by the statements.
Yes,
That
I'm saying,
we
I'm
can
saying, Malad.
understand it
Yes.
with-
Para, my lord, page 15. Page 15, my lord, first line. That respondent number only at the permitted 67 2, my lord. That mention another I have seen, my lord. I'm checking, my lord.
কোথায় রে?
67 2 mentioned.
কোনটা রে? Page 15 কি লিখেছে?
67 2, my lord, violation mentioned several places, my lord. My lord, and 10, my lord, last para, my lord, page 17. That 67, my lord, got my lord, 67 1 2 of the act, the respondent number only showed hurriedly INS 01 to the employee, but no such copy provided. Vital document ought to have served copy of the INS 01. Here reasons to believe that there is a spelling mistake. To evade payment tax not established, such entire proceedings is illegal.
Hence, reasons to believe. I do not have reasons to believe that you have to make a specific.
But this is question of law, my lord, question of jurisdiction. This is my
He
lord.
cannot take the
But he has
respondent by
written here
surprise.
reasons to believe to evade tax
Is not
not
established.
established.
Malad, established.
Such entire
Malad,
procedure
that
is
is
illegal.
not his entire case. He is, Malad, very good. Malad, then we will have to bring the entire records.
This is a question of law, and my lord, I am carrying, my lord, also other GST judgment in Allahabad High Court judgment, my lord. May I submit, my lord? Allahabad High Court judgment. Lordship.
No, Mr. Banerjee,
Lordship.
upon seeing the authorization, they can always say that you don't have reasons to believe. That they can say because they have said in the writ petition that INS 01 was never supplied to them.
Yes,
So they
later.
do not know what to comment. Now they are commenting. So
Yes.
they are justified in doing so. They
Malad,
they may not have said so in the writ petition. But now after the report, because they have said I have seen the first ground. First ground in the
it
writ
has been
petition.
shown to them. Our case is that YNS 01 was shown to him.
But they did not get the opportunity to look at it properly is what is the averment.
Malad, that they will have to inform or present before your lordship
See
within.
ground 1, as copy of authorization was not handed over, so it is not clear whether search was under section 67(1) or 67(2). So perusal of INS 01 is essential, as if it is under section 67(1), then the respondent number 1, and if it is under section 72, then respondent number 8 permitted to do search and seizure.
Yes, Malad. Malad,
And-
taking that, Malad, kindly see our search authorization. Malad, over here, his employee says seen and allowed. who was there at that relevant point of time.
Very well. Even if he has seen it there, and he is not precluded from taking the point, writ petition is has not yet been disposed of.
No, Malad.
So he can take that point,
Always.
saying that from the search and seizure, from the
Malad, then we will
authorization.
file a comprehensive affidavit. Report will be
In the
dealing
mean,
with
for the
statement.
purpose of interim order, what is your take on the
My lord, the
cash seizure?
cash someone because during the pendency of petition, several adjournment. And my lord, last occasion, Honorable Justice Ajay Basu Chaudhary also gave liberty to pray adjournment, and they shall consider the same as per last order, my lord.
Malad, Malad, kindly come to page 4
Of the affidavit.
of the affidavit of
Yes.
the report.
Report, sir.
Page 4, paragraph 12 onwards is our stand. 12, 13 and 14. With regard to the income tax. We have informed the income tax authority. My learned friend is appearing for the income
But
tax.
my lord, my respectful submission that income tax authority has no jurisdiction because seized by the GST authority. I will show your lordship the judgment, my lord. Bombay, Kerala High Court, Karnataka High Court, Gujarat High Court, Delhi High Court, subsequently affirmed by the Honorable Apex.
Malad, I have got a constitutional bench judgment which says it is permissible for sharing of all the misdeeds which have been found. It is for the appropriate authority to take a call. Malad, that is settled in Puranmal. Constitution bench judgment.
The copy.
কত প্যারাগ্রাফ রে তো নোটিংটা দিই
কত নম্বর প্যারা?
Para.
22, 25. আরে রাখি আমার নোটিংটা কোথায় গেল রে
22, 25.
22, 25 and 26.
22, 25.
25 and 26. Sorry, Malad. I apologize. Malad, para 25, page 22. Malad, I apologize.
Para 25.
Para 25, page 22. I apologize.
25. Yes, my lord. I will also submit, my lord, on the income tax context, my lord, in my favor.
Materials seized were liable to be used subject to law before the income tax authority against the person from whose custody it was seized. It is now even going on, Malad, this latest judgment of the Supreme Court in this NDPS case were found why these issues are going on because a small infraction has been held by the Supreme Court to be going into the jurisdictional issue and
No, but this definitely this can be done. But if you have authority to seize, if you don't have authority to seize,
Malad,
can
we
that
have
be there?
found it. We have found it. We have kept it in his custody and we have forwarded to the income tax authority.
No, but if you have authority to seize only, then you can seize and
Yes, ma'am.
forward it. Merely because you have seized it somehow and forwarded it, that does not make the action right if it is
Malad, that
otherwise
is for
not
the income
permissible
tax
in-
authority to decide. Malad, we have found some incriminating cash in the possession of the petitioner.
But whether you are authorized to seize it, that
Malad,
is the
we have
question.
stated, Malad, as an officer of the court, we do not. But
That
they have done it.
authority, that
That they have
authority-
done it.
That
It-
authority you don't have. If
Yes.
that authority is not there and that is set aside by court, then in that case it will be difficult. You will have to bring it back.
Yes, it is in his custody, in his possession,
No, I cannot.
possession?
The
In
white
his
petition,
possession.
but sealed by them, sealed
sealed
and
and
made
kept
re-
it in his possession.
and also
We have not
recorded.
taken
that
it in.
I cannot remove. It is my security problem now from my lord in the month of July. And
The source has to be explained as per 131 proceedings.
That you will
No.
be proceedings.
Ah.
That is a different proceeding.
different proceeding.
Whether he has authority to seize or not is the question.
That is why my lord, may I submit that judgment?
The proceeding.
And my lord,
It has
in the
become a very
last judgment,
clumsy matter now.
Yes, Malad.
my lord, in the last
Many
judgment,
branches of a tree.
my lord, in the last judgment, that Allahabad judgment, my lord, I forget, my lord, that INS 01 reason to believe not recorded for sole this ground, this set cost, my lord. That allowed. I have given, my lord. Allowed judgment and dawa. Excellent.
Yes, yes.
That, my lord. That,
ঠিক আছে, ঠিক আছে।
my lord. That is. যেটা হয়ে গেল এর পর থেকে বেরোলে পয়েন্ট আমি দিচ্ছি my lord. That, my lord, Kerala High Court judgment recently review petition also dismissed, my lord. Josh সাহেবকে দিন।
Well, let him make a compilation of cases. Well, he has made so much of researches, it will be very difficult to compete with
My
him.
lord, this is, my lord, Supreme Honorable Apex Court, departmental appeal dismissed, and Kerala High Court, my lord, in our favor, my lord, para 3 onwards, my lord. It's clearly everything written, my lord. Income tax authority had no jurisdiction. GST authority has no jurisdiction to seize. Para 3 onwards, my lord. Yes.
But this was done after affidavits, not at this stage.
And yes, and my lord, kindly have a look, my lord, section 275, my lord, once. 275.
275.
Yes,
52 or 2?
definition.
Which definition is other than money?
Other than
And
money.
nothing has to be seen. Is other than money, the definition of goods.
Goods.
2 subsection 52.
52 is the goods. Goods can be seized.
No, no, other than money.
Money,
Other than money.
ওটাই তোমার definition.
Yes, yes. Thank you.
ওটাই তোমার main. 2 subsection 52.
52.
Other than money.
No argument is required. But
For the cash, but entire search, my lord, for that reason to believe. And my lord, second
Entire
judgment, my lord.
search affidavits will have to be exchanged. Entire
Yes, my lord.
search at
But
this
my lord, the
stage-
stock may be released, my lord, because my lord is affecting the government revenue. I am honest taxpayer. Last year, my lord, 5.5 crore
Very
tax
well,
I have
not
paid.
today now, because we have already consumed more than 1 hour, and if I start dictating judgment, it will be
My lord, other judgment, my lord, for cash is cash relating to cash, my lord.
Give me
I am
whatever
also
it
giving, my lord.
for
Section 132 proceedings, how it is placed. Here, I'll set the whole Ahmedabad judgment, my lord, where police authority has seized the cash, my lord. Court has directed
Sir.
handed over to the income tax file.
that's right,
Yes,
but
yes.
the power of seizure should be there. If they don't have power of seizure, for example, if you get, I will go and search and seize and hand it over to you. My searching and seizing will be illegal. I cannot do. I don't have power to do that.
Yes, yes.
This is the question. Handing over to you is not in question. What is questioned is whether prior to handing over, taking it over was permissible.
Well, taking it over.
My lord,
Well,
Gujarat High Court. My lord, Gujarat High Court, my lord. Sir, Gujarat High Court. And my lord, Karnataka High Court, more detailed judgment, my lord.
হ্যাঁ, এত compilation করলে সুবিধা।
যত সময় পেয়েছি ধীরে ধীরে বের করেছি। My lord, আমি দিচ্ছি আপনাকে কপিটা স্যার। এই স্যারকে দিয়ে দিই। My lord, Delhi High Court, my lord. Sorry, এটা না, এটা না।
Very well.
These are the cash seizure. And my lord, I am also carrying, my lord, the reason to believe on the
Reason
point.
to believe, I said it has to be decided on
Our
affidavits. You
Yeah.
cannot get it right now.
I am carrying, my lord, 5-6 judgment on the.
Not required now.
Yes, ma'am.
That issue will not be decided without affidavit.
Only, my lord, our reply will be our averments in the report with regard to paragraphs, those paragraphs, and
I'm
if
not
the-
concluding hearing today
Yes,
because I will also have to go through all
Yes,
this.
yes,
My lord, another,
At this stage,
my lord, my lord, only 1 minute required, my lord. I know, sir.
1 hour has gone, Mr.
1 hour.
Rai. There are other matters
Yes.
also.
Two independent witness, my lord, independent on the point of,
I am only on the ground of cash
Cash.
now. Affidavits have to be exchanged
yes. My lord,
Only page 64 is our,
because without their affidavit
Yes.
on record, how will I decide
and my lord,
unnecessarily?
kindly grant my lord interim protection so that.
Let us see. Let me first come back with all these judgments. At
Yes.
this stage, if I start reading judgments, it will be
Yes.
2 o'clock with your matter
Yes,
only.
yes, yes,
That
yes.
cannot be permitted.
Yes, yes,
I cannot sit with one matter
No,
and
brother.
decide.
yes, yes, my lord.
till 12:30,
Ah.
my lord, your lordship.
Yes. Heard Mr. Rai, learned advocate, appearing for the petitioner, and Mr. Banerjee, Mr. Banerjee, learned advocate, appearing for the CGST authorities, and Mr. Bidhoria, learned advocate, appearing for the
Income tax.
respondent income tax authorities. Full stop. Now on the point of full stop. Now on the point of seizure of cash by the respondent CGST authorities. Full stop. List this matter for further consideration on 9th December.
9.
9th, any problem?
My lord, if it be, my lord, 10th, if your lordship will kindly accommodate.
10th, any
Ah,
problem?
10th.
10th, 10th December.
Lordship.
Yeah, here also, my lord, I am challenging the stock of goods also, my lord. They have,
Arre,
they
Nara,
have-
Challenge is all there. I
Yes.
am only
Yes.
on the ground of seizure of cash.
On 10th.
As in ওখানে লিখে দিন on the point of seizure of cash. As in না on the point of seizure of cash as an interim measure for the purpose of granting interim order. Right.
and there, my lord, they should not issue, my lord, the summons, my lord, because till my lord disposal of the writ petition. my lord.
আচ্ছা এর উপরে একটা লিখে দিন report filed একদম উপরে report filed on report in the form of affidavit filed on behalf of the respondent numbers 5 to 8 is taken on record আর একদম নিচে লিখে দিন যে it is noticed that
Several summon issued, my lord.
that by an order dated October 29, 2025, this court had granted liberty to the petitioner to seek an adjournment before the authorities on the returnable date. On the returnable date before the authorities, and the authorities were requested to consider such request of adjournment upon the same being made. Full stop. Paragraph. In such view of the matter, the same request is repeated.
My lord,
Full
only
stop.
one protection, my lord, since we will be suffering a limitation under the law because there is a time-bound program for completion of our.
When is it?
My lord, it is around 6 months.
No, 6 plus 6.
6 plus 6.
So when did this start?
My lord, it started. Kobhe start করবে?
Oh, honorable court may extend that.
My lord, that your lordship may kindly
That
consider.
will,
Pending.
but when did this? Because if it is not nearing it, I'll be finishing it.
No, no, not nearly, man. Not.
It is of 1st July. Sorry,
No,
my
no,
lord.
25th July.
25th July.
25th
Then
July.
1 year.
So used
Then
So-
1 year.
August, September, October, November. December.
Lordship may kindly clarify. Otherwise,
Then 1 year, man.
my lord,
6
sometimes
plus
we
6. Law says.
My lord,
6 plus-
clarify the pendency of this writ petition, my lord.
Yes, yes,
Will
yes.
give some benefit for the.
That will do.
That will do.
I'm
Because your lordship is not injuncting. That is the problem, my lord. We will be facing.
that I
your lordship-
conjunct when I pass the interim order.
Yes, I will remind.
If I say that there is a prima facie case of INS and all,
Lord.
once I go into all that,
I will remind. I will remind.
because cash is one of the issues,
Cash.
and the other issue is interim order should be granted here or not, so that further proceedings. Because if I hold at this stage or at the final hearing stage that the seizure, because the basis of the proceeding is seizure. Sorry, the search and seizure.
Search and seizure in respect, there are two components. One is the book seizure and the document seizure, and the second seizure
There
is
has
the
to be
cash.
an authorization, reasons to believe. If I am not satisfied that there is reasons to believe, then the entirety of that goes.
Lordship.
So as has been done by the Allahabad High Court. So
My
in,
lord, I shall also make the researches on the
yes,
next
you
day.
shall
so
also,
that-
but then on that day I'll prima
Lordship.
facie, upon my prima facie satisfaction, I'll grant stay.
Because
But before granting stay, I need to be prima facie
Lordship,
satisfied.
and my lord,
I do-
in the my lord summons and the report, they are mentioning that there is no stay of the honorable court, so we can issue summon.
No, I have said you will pray for adjournment. The
If
earlier
they
order-
again issue summon, they will again my lord.
Yes, yes.
That may be my lord.
Yeah, my
I
lord.
have written that,
My lord.
that you will make the same request.
Yeah, my lord. My lord.
Yes.
I'm grateful, my lord. So
The other four matters are also same thing.
same my lord.
Other three,
No, cash.
But my lord, in the
সবার নাম আলাদা আলাদা হবে,
My lord.
একই order.
in the no, my lord, in the second matter, my lord, third matter, fourth matter, the second matter, there is no cash seize, only stock shortage, no stock seize. And in the third and fourth
তাহলে
matter,
second, third, is there any cash seizure point in any other matter?
No.
Excepting this.
no.
সেকেন্ড থার্ড ফোর্থে এই অর্ডারটা লিখবেন, থার্ড মিস্টার সাসেন সাস নামগুলো দিয়ে দেবেন, ফুল স্টপ, না কমা, অন দি পয়েন্ট অফ interim order, grant of interim order, full stop, list this matter for further consideration.
But summon issuance of summon, that line may be inserted, my lord, here.
It's point of interim order only.
Yes.
10 December, 10. सब same heading है.
No.
Please give the names.
হ্যাঁ দিয়ে দিয়েছি না না আমাদের তো হ্যাঁ 4-5 আপডেট
Item number 3, the my lord, the past one.
আশীর্বাদ কল করুন একবার দেখি.
But I beg to appear on behalf of the states, my lord.
My lord, I'm for the petition, my lord, unauthorized construction, my lord, made on the Jila Parishad road by the my lord, respondent. My lord, and petitioner made a representation before the concerned authority, my lord. My prayer is, my lord, kindly consider my representation.
But there is an allegation that the private respondent has constructed his construction upon the land, upon the road which is maintained by the Jila
Jila
Parishad.
Parishad.
He made a representation. And his grievance is that representation has not yet been considered by the authority. Let it, my lord, give a direction to
You
the,
are appearing for?
I am appearing for the state, my lord.
Very well. লিখে নিন. The petitioner is petitioner complains of subdivisional officer, comma, what is the district? Subdivision, Diamond Harbour.
My lord, Diamond Harbour.
Diamond Harbour is subdivision.
Yes, my lord.
Diamond Harbour, my lord.
Subdivision. Subdivisional officer. If your affidavit of service is not ready tomorrow also, I will not take it.
Well, item number 8 is that matter where your lordship of
Yeah.
location passed.
Lordship, may I interrupt? I am from respondent number 1 in this matter.
Which matter?
8.
Item number 8.
Yes.
But it is that matter where on the last occasion your lordship passed an order
Yes. Mr.
allowing
J
me
was
to
there.
allowing me to apply for the rectified number of bill of entry. We have applied, and they are to submit the report before your lordship.
Mr. Day is not there.
Neither
Where is he?
Mr. Day nor Mr. Bhanju. None of
Not
them.
today.
Very well. My lord, not today will take us tomorrow.
Yes. No, today means tomorrow only.
No, because day after tomorrow I am not in town. That's why I was.
Tomorrow it will be there.
I'm paying for one intelligence, my lord. Say, immediate service.
Served upon all the respondents. দেখি তো একটু। না, না, এটা নয়, এর আগেরটা। No, you sub again. It contains the name of the erstwhile honorable judge.
Yes, sir.
লিখে নিন। None appears for the respondent numbers 8 to 12. Affidavit of service, the legal affidavit of service filed today be kept with the record. None appears for the respondent numbers 8 to 12. The petitioner shall serve another notice on the non-appearing respondents, intimating them that this matter shall be taken up next on December 12, 2025. 12 December. File an affidavit of service in the returnable due.
Well, I am for this petition, my lord. Lord, on the last occasion, my lord, here the challenge was to notification, my lord, extension of the period, my lord. And lordship has given me liberty to file a, my lord, to add the CGST authorities, my lord. But what I find is there will be a problem as because the prayer has to be amended. Government, my lord, that is not allowed, my lord, as per my knowledge, my lord.
No, by way of an application, you will have to amend it.
My lord, all three of them, my lord.
Yes, you will have to amend the writ
My lord,
petition.
my lord, then I'll do. Or otherwise, my lord, on the grounds of limitation, my lord, can be disposed of.
Limitation means?
My lord, there was a delay in filing appeal, my lord. That my lord, normal order of your lordship, my lord, that can be taken.
But the previous matter, I'll share the fully High Court judgment, but something has been said about INS. I'll share the judgment.
Yes, I need that. That is why I kept it.
No, no, there is one division bench, but I'll kindly see paragraph 8 and 9. No, no, just I'll share them.
Because I once I get satisfied, only then I start passing orders. Otherwise,
because what my lord felt that the same observation is there in that judgment, that reasons has to be there in the file. Not necessarily it has to be.
Yes, yes, correct.
But that is what my lord, that is the
Yes,
same
yes,
thing
yes.
there, my lord, in
Yes.
the High Court.
Yes.
That is also a division bench. I'm sharing.
that is why I, despite insistence of Mr. Rai, because I first have to be satisfied. Then I will record
with
prima
this
facie
1 month experience, I have understood that fact. And as officers of the court, we have to give the correct judgment.
I still do my own research work.
No, no, that I have understood.
My lord, that is why I stopped making the amendment to this, my lord. Well, I know lordship goes into the depth of these matters, my lord.
No, not even otherwise. Even when I was on that side, also what
Yes, yes.
little I had, I searched to the best of my ability and then made submissions. Now also, I am following the same practice.
My lord had shown me Rule 99 that at the stage of SMT also 10 interest has to be given. That my lord showed. I missed that one.
No, delay in filing appeal, my lord.
How many days delay was there?
My lord. Huh? No, I have not filed the appeal, my lord. I have not filed the appeal.
That's what.
My liberty can be granted, my lord, on payment, my lord. I filed the appeal, my lord.
No, but then delay has to be explained.
Well, delay has been explained, my lord, in page number
No,
Well,
delay has to
paragraph
be
number 10.
explained before the appellate authority, not before me.
But there are certain judgments, my lord, as to this also, on this point, my lord.
First, you have to approach the appellate authority with the predeposit, explain the delay, then.
But then I'll correct the petition, my lord.
File an application for amendment.
My lord, my lord.
It will take time because amendment will be allowed.
No, my lord,
That
it
will
was
have
ready. It was ready. Day before yesterday, I
So after that, the procedure is amendment will have to be allowed.
yes,
The amended writ petition will have to be refiled, then it will come.
my
So
lord.
it will take maybe 1-2 months.
Or my lord, liberty may be granted, my lord, to withdraw this application and file a fresh writ, my lord. But that will be easier, my lord, for me.
That can be done, but then there will be further delay of adjudication being there, order. How will you explain not approaching appellate authority? Lots of lions in the way.
My lord, I'll in that case, my lord, I'll be upon notification, my lord.
Huh?
I'll be on the point of notification only.
Even then, because when was this order passed?
My lord, the order was in
August
24,
2024.
August 24, my
And
lord.
it was filed in one
And-
after 1 year.
My lord.
If you have good grounds to challenge this order before the appellate authority, and if you have good grounds to uh, uh, seek condonation of delay of 1 year, why don't you approach the appellate authority and then come?
Well, no authority will be condoning it, my lord. That is for sure, my lord.
Now, if you have good grounds, then it can be
My lord,
condoned.
my lord, from the very top, my lord, the senior authority who is transferring these all, allotting, in fact, not transferring, allotting all these files, my lord, there's a strict instruction that no delay will be condoned. My lord, as because,
But
my
if
lord,
you have good grounds and if you fail there, then this court will.
my lord,
condone.
even, my lord, 1 day delay, my lord, 1 day delay is not being condoned, my lord. How, my lord,
No, if you have good grounds and the authority has not condoned, then against that, when you come to the court condones. But yes, ground has to be shown. There is no ground at all. Then in that,
my lord, the ground is of the accountant, my lord, and this court,
that
my lord,
is
this court has,
then you amend it. That
my
is
lord,
better.
my lord.
Amend it. An adjournment has been prayed for on behalf of the petitioners. Full stop. This matter after
But
2 weeks.
my lord, 2 weeks.
2 weeks.
Clear floor.
Lordship, I am for the petition.
Yes.
Lordship, on the last occasion, report was some instruction was sought from them.
My lord, there are two aspects. I've seen the appellate order. My lord, the points raised by my lord was not taken care of. My lord, I think
What was the
my lord,
point?
one was the issue of export subject to correction.
Yes, yes.
One was the export. Another, he says that he's 243 Q of the Constitution, but he's exempted. But because he only supplies labor. But that point was also not taken. But at the same time, I must say that export documents were not handed over to the authorities at that juncture. What they wanted to show, not all the documents were there. Malad can remand back the matter because there was not.
How has the appellate authority
They
dealt?
are not dealt with in the proper. In a,
Where is the appeal? First, show me what the points that you have taken in the appeal.
Lordship, the appeal petition is in running page number 102.
102.
Yes, my lord.
Yes. What was the point that you had taken? Show me.
Lordship, there was primarily 3 points. First point was our claim of export, which was not allowed as export but as exempted sales. And in case they consider
Your claim of export was
not considered by them, it was considered as exempted sales.
exempted sale.
Yes.
And you wanted it to be considered as
Export
only.
Export, yes. Then only my ITC is
just-
allowable.
Where do I get that in the appeal?
Lordship, page 106.
106.
11 minute finds under the 11 he has given the export documents.
And Lordship, in the appeal order, it is also recorded, Lordship.
What was the ground for the appellate authority to not consider it as an export?
Lordship, in running page number 118, that's the appeal order, my lord.
118.
Yes. The appeal authority in the 4.3 paragraph,
Yes.
the last part was the order. The appeal authority stating that the goods movement from Siemens Goa to Kolkata has been established, but whether the goods have crossed the customs frontier of India or not is not supported by documentary evidences. That's what the appellate authority is saying. But at the time of hearing, we have supplied page number 73, my lord.
Page 73.
Yes. Lordship will see in the upper part of the page, left side, the final destination is clearly written as Birganj,
And how
Nepal.
do I know that this was produced before the appellate authority? Page 73.
That is a matter of record, Lordship. This was
No, but,
provided.
somehow, because anybody can come and say before the writ court that this was provided, this was not seen. How do I find fault with the appellate authority's order on the basis of a mere submission by a person that this was shown and it was not taken note of?
Lordship, it was with the appeal petition, then the entire
was
appeal
with the-
petition,
it
because
was-
appeal was filed online.
It
Then
was it formed annexure to the appellate petition.
yes, that I'll
Do
have
you
to
have
check.
any averment to that in the writ petition?
No, Lordship, I'll have to check.
Next ground.
Next ground, Lordship, it is also covered in the appeal order, Lordship. In same page, page number 118, upper part, Lordship. That's in the previous page, 117. Two specific bills were quoted.
Two bills, yes.
Yes, and those bills were actually supply of labor, pure labor job to the NKDA, which falls under 243G of the Constitution, Lordship.
Right.
That was not considered. They are stating, the appellate authority in the very next page have stated that no information regarding the procurement of goods and or services to execute such work order has been produced in the page number 118 top part.
Right.
But Lordship, in supply of labor, how can I produce details of goods procured? My stand is there is no goods involved.
Right. So this is.
My
This is
stand
incorrect.
is there
If
is
it
no
is-
goods involved.
Mr. Chakravarti, if
I
his case
said,
is
but-
supply of labor, then he has gone. in
He
the-
has asked for production of procurement of goods.
No, but he says goods and or services. Services will cover labor.
Yes, services is the labor part.
Then
Lordship.
so he says no information regarding.
Lordship, bills were produced. These specific bills are also attached, my lord.
And that this also.
Work order is also attached, my
This
lord.
also you had filed with the appellate.
Absolutely, because otherwise, how can the appellate authority quote the
My lord,
bills?
But then how is the appellate authority mentioning so confidently that nothing was produced? If you had produced everything, why will
Bill and work order was produced. The work order clearly states.
Then what is it that
what he
on
has
the
The
basis of
SSC code, Lordship. There is a confusion.
106. B. Kindly see what he has stated.
106 B.
106. That is his condition. ITC exempted on the exempted sales so and so on account of work at India not allowed by the ITC officer, although there was no registered advertisement by us in providing this service. Major amount expended on his job was labor and negligible amount of unregistered materials. But it's also vague, what unregistered material, because if he's supply, this is vague. That's why I said, it may be, can we keep this order in abeyance, let him take all the point what he is asking, and let the appellate authority consider these issues, because these are factual disputes, and the authority should also.
Because you see, there is nothing on record to show that these were really produced before the authority. That I can do. This is a fair suggestion. That I'll keep the order in abeyance.
Okay.
give you an opportunity to produce these documents before the appellate authority. If
Absolutely.
the appellate authority is satisfied with this, then this order shall stand recalled. He'll pass a fresh order.
Lordship.
And my lord, authority.
But then the authority will recall order on what basis? Authority cannot recall.
My lord, if he is not considered in the right spirit, my lord, he can always recall its order. And it's a court's direction.
There is a provision to recall.
There is no.
There is no provision.
No Indian, my lord, you need right to review.
Then how can the court vest the authority with power to recall?
That cannot.
Lordship
Lord,
can only
please
set
avail
aside the order. If my lordship may set aside the order.
Set aside, but then give me the handle. Give me the footing on which I can make my order stand.
Submitted man authorities may also consult the custom authorities to ensure whether the goods have actually come from outside or not.
That customs document I have produced because we have got it
So
on
you
a
have
later
said that
state.
you
I
have
have produced it
but
here,
where,
Lordship.
where do I get that you have
Custom
produced?
authorities, but he also submits, he has produced it now. He
Yes.
did not produce it at the time.
That was not
These
with us
documents
at the
were there
time.
before the adjudicating officer.
Adjudicating officer, I am not sure.
No,
Lordship.
nothing
I'm
was
not
there
sure.
before that.
Then,
But in the appellate stage, we have produced, Lordship.
but where do I get that from? Any averment in the writ petition, anything, anywhere?
Lordship, let me just once go through.
Or Mr. Chakravarti, you file a report then, whether these were produced or not. Because they, whatever he has produced, it will be through the portal only. Those will be there on the portal. That will make things
But I'll
clear.
then file whatever he has produced with the.
Yes, that will make things clearer. Then we will not be hunting in the dark.
Yes.
Unnecessarily, somebody's submission, somebody's
Yes.
recording. How do I find fault with the officer?
But that is true, brother. That is true.
Lordship, if Lordship, 1 minute, Lordship. BRC 01 এর যে অ্যাপ্লিকেশন পার্ট বি ছিল সেখানে বোধহয় অ্যাটাচমেন্টটা দেওয়া আছে।
Let them file a report. That will be better. That
Lord.
will be clear. Mr. Ghosh, learned advocate, appearing for the Yes, there was this.
Yes, not everything has been solved, refund order has been issued.
Only interest part remains. Interest.
He has tried to explain why, because this is 2006-7. Lordship will kindly see paragraph number 6 on next page, and also the refund order is there. Last next refund has been made 58,000. But this is the entire and the calculation of GST. Everything has been done. But your lordship's intervention, they're not tracing, they're tracing. Subsequently, I told them this is what happened. Lordship will kindly see paragraph 6. He has tried to explain that because of the old and everything. Then thereafter, rectification order was passed. Refund has been given. It is there last page, 58,000. This was the only period. Refund is pending.
Yes, Mr. Dhuria, what about interest? He's claiming interest.
In 6-7 interest was given. Calculation in interest, his principal amount was 45,000. Interest was given and
8,581. The amount of interest I have received yesterday, along with the principal amount. Now my claim is 45,000. 45,000 minus 8,581.
His calculation is how he has come to this 45,000.
Yes, how have you come to the calculation? What is the
Let
amount
may I
of
come back with
interest?
the supplementary affidavit with the calculation?
Come with the supplementary affidavit. Because, and what is the interest which they are entitled to get? What is the percentage?
6% per annum. 2022 July to 2025.
6%. Where do you get? Which law?
Well, this is the
No. According to your own wish, it won't be. It has to be statutory, whatever it is. Mr. Dubra, take instruction. What is the percentage of interest? Because they have also made their calculations. If they have made their calculations, they give you interest on that. Because at the normal savings bank rate, what will you get?
Percent.
Or what was the total sum? 5 lakh and not?
no. 2,24,822 was the principal amount.
Out of which
Initially they have paid 1,75,664. The remaining amount was 49,852. But yesterday morning I have received a sum of rupees 58,433. So additional amount of 8,500.
For how long was it there?
For 40 months. If I calculate from July 2022 to December, today is December 2, 2025, 40 months, 41 months. I have calculated on the basis of 40 months till November 30. Then
you have got the principal sum.
Yes.
According to you have not got full interest. You also bring a calculation chart. You also bring a calculation. Mr. Dudhoria,
may I get a copy of the report?
Yes.
Alright, I am fine. I'll come back in 5 minutes.
this is a matter of registration cancellation in the year 2018. My lord had asked me to take appropriate instruction whether something can be done. My lord, kindly take this matter after 15 December. Something will be done in the meantime. Because the concerned officer could not locate the file, but 2018 the cancellation of registration. But what was the actual reasons for it? It's taking time. I have said, but unofficially go and visit whether if he still is there in that place or he's doing some business. Let us continue. But I have told them unofficially because there was no formal order.
As prayed for by Mr. Chakraborty, as prayed for.
And note this judgment. This is all
That was apparent from the reason of, I mean, from the reading of the statute.
has to be there. And next paragraph says that it is not necessary that I have to communicate the
Correct,
exact.
correct. Even that was my understanding. কল করুন কি দেবো কি কল করবেন
This is a fund matter. This will take time. This will not happen. This can come back next week. This half an hour, my lord. I don't think expiry of 2 years of the refund. That is.
Oh, that may and shall something.
May and shall.
May apply.
A lot of judgments are there.
Yes, ma'am. Both ways. But I have. But Lenovo has started the trend, making it to be directory. Before that, trend was more or less mandatory. Because I was trying to find the expiry. All there is a timeline, like 73, there is a timeline for adjudication. There is a timeline for everything.
When do you want? Tell me.
Well, next week.
Next week.
Next week.
Next.
As
My lord, today, my lord, I am asking for an adjournment on the ground that, my lord, I am being led by Mr. Subir Sanyal, my lord. He's on his legs. So, my lord, kindly keeps it on some other day.
as prayed for by the learned.
Or in this matter, provision under section 148A4, 148(3)(4), and the scheme are under challenge. My lord, there is a similar matter in the original side, which is led by a senior advocate, which is listed at item 10 of today's list. My lord, I am humbly praying for a not today.
Millard may meet with then mean after week. Monday week. Very well.
My lord, it may be kept on Tuesday, my lord, 9th.
Tuesday.
Up next to next week. Yes, yes, my lord, next to next.
Tuesday week. That means 16. 16.
This week. Item number 16, not this week.
Not this week. Why?
Mr.
Last
Seeger
time
has
also you-
already told.
My lord, conducting council is just
Appear the item number 13.
Acha.
Also told.
Not this week. Very well. এটা not this week করে রাখুন লিস্টে দেখাবেন না not this week করে তা এক সপ্তাহ পরে ডেট দিয়ে দিন হ্যাঁ হ্যাঁ ওই এনটিডব্লিউ লিখবেন না লিস্টে
হ্যাঁ,
17 17
My lord, your petitioner actually is in the business of providing renting service of machinery. They have their office at Calcutta and Vizag also. So initially, whether the renting service is under service tax or under VAT, this was under dispute.
who is appearing for the other side Union of India is the answering respondent
No, CGST.
you have served all the respondents
Yeah, my lord.
he and Mr. Bonjo is appearing. They are engaged in 759. Not today.
I'm making it not today come tomorrow রেখে দিন yes
Right after the petition.
I am extremely sorry that I because your lordship had directed us to file a affidavit in the form, a report in the form of an
Affidavit, yeah.
but my lord, due to illness of the officer, she will not come and sign it.
when should I keep
Kindly give us one minute.
Mr. Dutt, learned senior standing counsel appearing for the respondent.
Lordship, I am for the petitioner. Lordship, this is that matter wherein there was a delay in filing the writ petition. Lordships, approximately 2 years. Lordships, I have a supplementary affidavit in this regard, Lordships, so kindly consider.
Very well. What is the, where is the appellate order?
Lordship, the appellate order is at page 79, page 77, Your Lordship.
And when was the appellate order passed? 11th of May 2020.
Yes, Your Lordship.
And this appeal was disposed of on merits.
No, Your Lordship. This was disposed of for the reason of non-payment of pre-deposit. Lordships, thereafter, the entire tax amount has been recovered from the electronic cash credit ledger. At page 78, I have annexed the credit ledger.
Yes, Mr. Chakraborty. Let the appeal be heard now.
There are two aspects. For one matter, he had approached the Honorable High Court. If Mala sees 73, the same petitioner. So, other matters he did not approach contemporaneously. So the issue is, I'll leave it to Lordship because today, the entirety has been recovered. But this case, should not be allowed to be refunded. Let us.
I am not asking for refund, Your Lordship. Not at all. Not at all.
Deposit he does not. We should not insist once we have recovered the entire money. Let us hear out the matter, and there should be subject matter. Refund would be subject matter of the.
Lordship, I am not asking for refund at all.
Which is, which item did you say he had appeared?
Page 79.
Page 79.
Of 79. He had filed a writ petition in 2023 itself.
Yes.
Oh,
Yes, that was
Yes, Your Lordship.
noticed by me and indicated name on the
Your
last
Lordship.
ticket.
This went against me, Your Lordship.
Very well. Likheni. The petitioner is aggrieved by an order dated
the matter, my lord, before a coordinate bench. My lord, at the time of mentioning, m- yes. My lord, eviction proceedings against me was stayed by an order passed, my lord, in my writ petition. My lord, thereafter, my lord, when we tried to, my lord, mention the matter for extension of the interim order, my lord, we were unable to have the matter listed because, my lord, the court was occupied and busy with other cases. Having said so, my lord, a learned senior appeared for the, my lord, union and said that so long as this matter is not being taken up, no adverse steps will be taken against us and the proceedings will not go on against us. This was, my lord, submitted at the bar, but the matter never came up, my lord, for extension. My lord, in violation of, my lord, that oral confirmation, now, my lord, on the
Oral
11th of December,
confirmation-
my lord,
confirmation is of no consequence. Why did you not take steps for getting the interim order extended?
no, my lord,
There was a formal interim order passed. It ought to have been extended.
no, my lord, we tried to, my lord, have the matter listed. My lord, at the time of mentioning, my lord, the learned
You
judge
could
was
have
of the
filed
view
an application for
since-
extension. If
for-
the order had expired,
for
interim order
restoration.
had expired.
Very well, my lord, we'll do that, my lord, at the earliest.
My lord, may I be permitted to mention a matter? Your lordship, this is for upgradation. It is running as item number 88 of today's list.
88.
Yes, your lordship.
88 is what matter? Hearing matter. Why upgradation? What has happened?
Your lordship, petitioner is facing statutory difficulty for not issuing the certificate of 80G.
80G. Very well. 88. একটু দিদি এটা নোট করে রাখুন তো। Very well.
Grateful, your lordship.
একটু আপগ্রেডেশন একটা কিছু হিয়ারিং এর ডেট দেবো আর সামনের সপ্তাহে করে দিন।
Item number 1.
My lord, I apologize at the outset for butting in this matter, my lord, but kindly hear me for 20 seconds. I apologize in advance. My lord, I appear for the Tea Association of India. I'm the association of all the tea manufacturers. My lord, it's only recently that my members have told us that this writ petition is pending where a particular notification is being challenged, which concerns the branding of teas. Now, this notification is exclusively and primarily for my benefit as well, because I get directly affected by whatever happens with this notification, whether it's kept alive or whether it's set aside. My lord, I am told, my lord, we do not have a copy of the writ petition or any of the details of the proceedings. But I'm told, lordship, that
party to the proceedings.
my lord, I'm not a party to the proceedings, which is why we don't have all the details. My lord, I am only making a very limited prayer. I'm told that the hearing has been on. We do not want to disrupt the hearing. But if lordship gives us only one small indulgence, which is, my lord, if
it's
my lord,
not a public interest.
lordship, if we are no, because lordship, I make this submission because we, based on our assessment of what these proceedings are, and it concerns that notification, we are evidently necessary parties to this litigation, because what happens in this litigation, the only person who is directly affected by it is us, because we are the tea manufacturers. It's in our interest whether what's an Indian or origin tea or what is a multi-branded. That is only the leaf which is.
Don't need
It is
right in law.
This is
apply and get added.
this was not a matter of law. I was mentioning only as a matter of propriety because lordship had been hearing this matter. We felt that just simply filing
I don't know. It may be concluded today also. And what is the use of now?
We are here only arguing on a point of what my learned friend is arguing, where virus of the act, virus of the notification, etc. is challenged. If the case is something relating.
And in any case, if it
is something on the propriety of the litigation notification and the circular. That is all.
File an application.
File an application.
Only we will file an application by tomorrow itself. The only my lord, only lordship will give us 3 days time in that case, lordship. Only 3 days. Lordship will not make it CAV for only 3 days. We'll take all necessary steps in the meantime. And lordship, and
He must
my
be
lord,
watching from the external.
my lord,
He must be set up by somebody nowadays.
lordship,
Yes, sir.
my lord, we are all the team manufacturer. We are all the
Who am I?
Very well.
we-
Started mentioning
Lordship,
the matter without-
lordship, we shall. Lordship will kindly keep in mind. Lordship will give us these 3 days. That's all, lordship.
Let us see. Yes.
Well, let
Grateful,
him like
grateful.
that and inform my advocate and record on whose behalf he has mentioned the matter.
My lord, the Tea Association of India. I am the association for all tea manufacturers.
Sir, India is not a party to this process.
You are not a
My lord,
party.
which is why I mentioned. My lord,
Like-
which is why we are
Yes,
mentioning.
This is
Great,
not the
great.
manner in which one can be done.
My lord, we could have filed an application, but as a matter of propriety, I chose to mention only
Very
as a
well.
matter of
He has challenged the SOCA.
grateful.
Yes, Mr. Tiwari.
But so far as my land defense case is concerned, blood, I'm just recapitulating. Blood, he has filed this writ petition challenging one notification that is appearing at page 42 of the writ petition. His main contention before your lordship is this: this notification never notified in terms of section 31 of the control order. The provisions of the control order has not been challenged. His case is this: it was issued by a person who is not competent to issue such SOCA notice. On the last occasion, I shown to your lordship, the deputy chairman is the authorized person in terms of the notification issued by the central government in the year 2016 itself. So, so far as his case is concerned, that your lordship kindly consider two things. The SOCA notice can be challenged by anyone only on the ground that it was issued by a person having no authority to issue this, or it has in violation of the provisions of the Act. Now, my learned friend has taken two grounds, mainly two grounds, that its SOCA notice was issued in terms of a notification which was never published in terms of the control order, and SOCA notice was issued by a person who has no authority. Now, in terms of the order passed by this honorable court, now, hearing was concluded. Hearing was concluded, we could not pass the order as because there is an injunction not to give effect to the order passed by this honorable court. Now, so far as this SOCA notice is concerned, my first responsible submission would be Bureau Lordship. Nothing has been it does not affect the rightful interest of anybody. If SOCA notice issued by an authority having authority to issue the SOCA notice, he will give answer, authority will decide. No right and interest, nothing has been affected by issuing the SOCA notice. Your lordship knows better. Well, SOCA notice does not deprive anybody to give answer to the SOCA notice. And it is basically a process has been initiated, and in that process, somebody will go there, file objection, and authority will proceed with the matter. Now, regarding this authority of the person concerned, issuing the SOCA notice, and the last occasion I have shown to your lordship, there is a power in the Tea Act itself, in the section 30, subsection 3 and subsection 5 of the Tea Act, specifically deals with that in such cases that government can issue control order in terms of section 30, subsection 3 and 5 of the Tea Act itself. Now, in the Tea Act, there is a provision that the government can issue bylaws as well as rules. In the Tea Act, there is a complete provision is there, the section 49 and 50 of the Tea Act itself. Section 50 speaks about the bylaws, section 49 speaks about the rules. So, my responsible submission would be before your lordship that so far as delegated legislation, my learned friend is harping on, this is not at all a delegated legislation at all. Delegated legislation can be said, the control order can be a delegated legislation. That was issued in terms of section 30, subsection 3 and 5 of the Act itself. Now, in the control order, the power has been given to the authority concerned. If your lordship kindly takes the control order first, kindly takes supplementary review. I just place 2-3 provisions of the supplementary review in the control order itself. If your lordship
Yes.
If your lordship kindly takes the supplementary review, page 8.
Supplementary agreement.
Supplementary.
Yes.
Now, my lord, your lord would find this control order was issued in exercise of the power conferred by subsection 3 and 5 of section 30 of the Tea Act and in superstition of the Tea Distribution and Export Control Order 1957, except as respect things done or omitted to have been done before such superstition, the central government hereby makes the following order, namely. Now, my lord, this is the control order, my lord. This can be termed as, my lord, delegated legislation. Now, my lord, kindly takes, my lord, this control order. Once, my lord, kindly takes, my lord, page 15 of the supplementary affidavit.
Page 15.
Page 15. Page 15 says, my lord, grant and refusal of non-preferential certificate of origin. The licensing authority or any officer of the board not below the rank of joint controller of the licensing authority duly authorized by the licensing authority or any inspection agency duly approved by the licensing authority may, for reasons to be recorded in writing, refuse to grant certificate of origin to any exporter and shall furnish him with a copy of the order so passed. On the last occasion, my lord, your lordship, my lord, there is one query that so far as this part is concerned, any inspection agency duly authorized by the licensing authority. Your lordship has raised the issue that any inspection agency can issue this certificate. Now, my lord, if your lordship, my lord, kindly turn the how this certificate was issued, page 34 of the supplementary affidavit. Now, my lord, this is the form, page 34 of the supplementary affidavit.
Yes.
Form E.
Form E.
Form E. Now, my lord, you also find this is the format of certificate of origin non-preferential. Now, this is the format, my lord, all these things are there. Now, in this format, my lord, I will be showing to your lordship the certificate which has annexed in the petition also, how it was issued and who has issued that. Now, this is the format of certificate that has to be issued by the concerned Tea Board or any inspection agency, my lord, authorized by the licensing authority. Now, if your lordship, my lord, kindly, I will be showing to your lordship, my lord, 2-3 pages of the petition. My lord, kindly takes, my lord, page 78 once.
Yes. Page 78.
Page 78. Now, you lords would find page 78. This is certificate of origin non-preferential. Well, it says, well, can you see who has issued this? The Merchant Chamber of Commerce and Industry.
Yes.
Now, the question is whether Merchant Chamber of Commerce and Industry was authorized
or
not. Now, my lord, I will be just showing to your lordship, my lord. Your lordship, my lord, kindly takes, my lord, this is the agreement. Now, my lord, kindly see, my lord, the scheme on issuance of certificate of origin. The scheme on issuance of certificate of origin non-preferential for tea. Now, my lord, this document is such and such, who is Export Inspection Council of India. This, my lord, Export Inspection Council of India was authorized to issue this certificate. Now, my lord, I will also show to your lordship, my lord. Can you take, my lord, another document? Now, my lord, my London friend has, my lord, referred, my lord, DGFT Act, Customs Act, and all other provisions of that. So far as this DGFT is concerned, you'll also kindly see this. This is the notification issued by the Director General of Foreign Trade. Now, in this, you'll also find your lordship kindly turns page 17 of this bunch. Now, you'll also find that for export of tea only. Yes. The center of this. 17, 17.
Yes, 17.
Yes, 17. Now, you'll also find for export of tea only, certain entities under the different states were mentioned. Now, kindly turn page 19. That is so far as West Bengal is concerned.
Page 19.
Page 19.
Yes.
In West Bengal, the three entities, number one, Messrs. BCI Inspectorate India Private Limited. Number two, Messrs. Cargo Inspectors and Superintendents Company Private Limited. And number three, Messrs. Tea Research Association. These three entities, were entrusted to issue the certificate in respect of DGFT matters. Now, so, it is admitted fact.
Yes.
That so far as this certificate appearing at page 78 of the writ petition, this was issued by an authority who was not even approved by the tea board. That is certificate of origin issued by non-preferential, issued by one Merchant Chamber of Commerce and Industry.
Yes.
Now, my lord, the same thing, my lord, I just repeat to your lordship, my lord. Your lordship, kindly take the reply once. The affirm by the writ petitioner.
Reply.
Reply. Bulky one.
Yes.
Now, in reply, I will be referring to 3 pages only. That is page 64, 65, and 66.
Reply is bulkier than the writ petition. No?
Yes. My opposition is 10-15 pages. Reply is more than near about 171 pages.
There are only annexures enclosing their document mostly. This
64.
Page 64.
Yes.
But lordship finally, that is
this tea board has nothing to do
nothing
with
to do. Page 64. Now, Malal, can you see page 65? Can you turn page 60?
Document from tea board portal.
Yes. Page 66 once.
Yes.
Page 66, my lord, my land reference client is writing a letter to whom? To the Director General, Merchant Chamber of Commerce and Industry for what? Letter of issuance of certificate of origin non-preferential. So, on the basis of this letter, this page 78 was issued.
Yes.
Now, my lord, kindly turn to supplementary affidavit once.
Supplementary affidavit.
Yes.
Yes.
Now, my lord, kindly text my lord page 23.
Page 23. Yes.
Page 23, my lord, paragraph 32 of the control order. It says the service of orders and directions. It says, my lord, I'm just placing, my lord, I have my learned friend also placed, I'm just placing once again. Any order of directions made or issued by the licensing authority or by any other authority under this order shall, in case of an order of general nature or affecting a class of persons, be notified in the official gazette. And in case of an order directed to be specified individual, be served on such individual. By these are the modes: by delivering it or tendering it to that individual, and it cannot be said to deliver, and all these things. Now, my lord, this paragraph 32 speaks about the service of orders and directions. Service of orders and directions. The T Act specifically says, my lord, section 16A(1)(d). It says, my lord, order has to be notified. Order has to be gazetted. If there is an order, it has to be gazetted. Now, my lord, kindly take next page, page 24. That is, my lord, power to issue directives by the licensing authority or any officer of the board authorized by the licensing authority. It says the licensing authority or any officer not below the rank of controller licensing, duly authorized by the licensing authority, may issue such directive that he may think fit to the licensee or class of licensees at any time for compliance within the time period stipulated in such directive, with regard to the adherence of the contractual obligations, maintenance of requisite quality of tea and packaging materials, as well as on any matter relating to tea shipment, including stoppage and recall of shipment for violations of any of the provisions of the control order, or any other matter relating to export or import and export of tea. Now, my lord, I am drawing a distinction between the direction and directives.
Orders according to you have to be gazetted.
Yes.
Directives
It
may not
cannot
be
be-
gazetted.
and
Not required.
Not required. Number one. Second point is, well, order or direction. So far as direction is concerned, it may not be mandatory. But so far as directive is concerned, it has some authoritative value. It is basically mandatory in nature. Directives are obviously mandatory in nature. And directives, I am deriving the power in view of paragraph 34. So directives are not required to be published. Because otherwise, tea board cannot function. If every directive is required to be gazetted, then in that case, tea board cannot function at all. Now, I have shown to your lordship, there are two notifications issued, that is appearing at page 42 and 43 of the notifications. Out of these two notifications, one notification he is complying. And in the notifications, my learned friend also pointed out that the first, can you have two notification once? And I'll be very short, page 42.
Page 42.
Page 42. Your lordship would find, this notification was issued on 22nd of December 2021. First paragraph says, the point was taken, whereas in exercise of the power under subsection 3 of subsection 3 and 5 of the Tea Act 1953, the central government has notified the Tea Distribution Export Control Order 2005, hereunder refer to the said order, to exercise control over export, import and distribution of imported teas in India. Now, section 30 is missing. There is no doubt. But this paragraph speaks about this notification. This paragraph, speaks about the notification which was gazetted. So, section 30 may be missing in this notification, but nobody can
Speaks about the control order.
Yes, this speaks about the control order. This notification, first paragraph, speaks about the control order. The control order issued in terms of section 30, subsection 3 and 5 of the Tea Act. So, here, your lordship would not find section 30 is there. There is a mistake. Now, in that case, what would be the interpretation? Your lordship knows there is a Ganga clause. Ganga clause says, if there is some lacuna, the court should interpret in such a way so that a logical conclusion comes. So, it cannot be interpreted in such a way as because section 30 is missing, the entire notification goes. So, by applying the Ganga clause, we must come to a conclusion that intention of the party was to insert section 30. So, it is basically nothing more. It is basically quoting the control order. In the control order, section 30 is very much there. So mere missing of section 30 cannot render the notification, my lord, absolute null and void. So, my lord, by applying the Ganga principle, my lord, my responsibility would be that Ganga principle is this, that if there is any lacuna in the statute, the court should interpret in such a way so that the statute should not render it yours. Yes, GNG. Sir, it is coming from Kaveri Dispute Act. The Supreme Court interpreted it in that. In the Kaveri Dispute Act, this principle was applied by the Supreme Court. Water dispute between the Karnataka and this Gujarat and other states. Now, my lord, if you lordship, my lord, now I will be just showing to your lordship, my lord, one page of the reply that two notifications I have shown to your lordship, that is page 42 and 43. So far as 43 is concerned, my learned friend clients is very much complying in the same. And the same would be evident from the, my lord, everywhere in reply, page 25, paragraph 14.
Page 25.
Page 25, paragraph 14.
Paragraph 14.
Paragraph 14. May I just place it, my lord? It says, with reference to paragraph 10, 11 of the said every, I repeat and reiterate the paragraph 50 to 62 of the petition and each and every allegations contrary to such and such. I state the notifications.
Placed it.
Yes.
Is vague and evasive.
Yes. Vague and. Now, my lord, just in this background, my lord, I just place, my lord, few judgments to conclude my argument. (1985) 1985 forests. First judgment, my lord, that is 1985 4 SCC 628. Lord, if your lordship, my lord, kindly takes, my lord, paragraph 1.
Para 1.
Para 1. Para 1 says, my lord, what is the subject matter? It says, my lord, in these petitions filed under Article 32 of the Constitution, the petitioner challenges the constitutional validity of the election symbol, reservation and allotment order 1968, hereinafter referred to as symbol orders, which is issued by the Election Commission, hereinafter referred to the Commission. The principal contention argued by the petitioner in support of his contention is that the symbol orders, which is legislative in character, could not have been issued by the Commission because the Commission is not entrusted by law the power to issue such an order regarding the specifications, reservations, and allotment of the symbol order that may be chosen by the candidate at the election in the parliamentary and assembly constituency. It is further argued that Article 324 of the Constitution, which vests the power of the superintendence, directions, and control to all elections to Parliament and to the legislature of a state in commissions, cannot be construed as conferring the power on the commissions to issue the symbol order. Now, my lord, this was the subject matter. Now, my lord, if your lordship, my lord, state where it comes to paragraph paragraph 16.
Yes.
It says, my lord, even for any other reasons, it is held that any provisions contained in the symbol order are not traceable to the act or rules. The power of the commissions under Article 324(1) of the Constitution, which is plenary in character, can be encompasses all such provisions. Article 324 of the Constitution operates in areas left unoccupied by the legislature, and the word superintendence, control, directions, and control, as well as the conduct of all elections, are the broadest term which would include the power to make all such provisions. Now, my lord, kindly take, my lord, paragraph 17. Paragraph 17 says, We do not find any substance in the contention that the central government, which had been delegated the power to make rules under section 169 of the Act, could not further delegate the power to make any subordinate legislation in the form of symbol order to the commissions, without itself being empowered by the Act and make further delegations. Any part of the symbol order which cannot be traced to Rule 5 and 10 of the rules can easily be traced in this case to the reservoir power under Article 325, 324(1), which empowers the commissions to issue all directions necessary for the purpose of conducting smooth, fair, and free elections. Our attention is not drawn by the learned counsel for the petitioners to any specific provisions in the symbol order which cannot be brought within the scope of either Rule 5 or 10 of the rules or Article 324 of the Constitutions, and which is hit by the principles of such and such, and delegate cannot delegate. The commissions itself, in this case, being a donee of plenary power under Article 324 of the Constitution, in connection with the conduct of the elections conferred to therein, subject to the courts or any legislations made under Article 327 and 328 of the Constitution, read with NT 72 list 1 and NT 737 in list 2 of the 7th schedule of the Constitution, and rules made thereunder. Now, Willard, while constituting the expression superintendence, directions, and control in Article 324, one has to remember that every norm which lays a rule of conduct cannot possibly be elevated to the position of legislation and delegated legislation. There are some authorities or persons in certain gray areas which may be the source of the rules of conduct and who at the same time cannot be equated to the authorities persons who make the law in the strict sense in which it is understood in jurisprudence. A directions may mean an order issued to a particular individual or a precept which may have to follow. It may be a specific or general order. One has to remember that the source of power in this case is the Constitution and the highest law of the land, which is the repository and the source of legal powers, and the power granted by the constitutions for specific purpose should be construed liberally so that the object of the power is granted effectively achieved. The views from the another angle, it cannot be said that any provisions of the symbol order suffers from want of authority on the part of the commissions which has issued. Now, my submission would be that the direction and directives, again I am repeating the same thing, the directions issued under, it has to be gazetted. So far as directives are concerned, the authority has the power. Authority can issue the directives in the guise of control order which was issued, which is a delegated legislation. So the power is there. For issuing the directives, the power is there, and the authority had issued the power, exercised the power in terms of the control order, which is a delegated legislation. Which is a delegated legislation. Now, kindly takes another 2008 8 SCC page 44. Now, and the next one is 2008, volume 8 SCC, page 42.
Yes.
Now, straightway, Lordship Council, paragraph 38, page 54. Paragraph 54, page, paragraph 38, page 54.
38.
38. I'm sorry, sir. I'm sorry.
No. Page 54, paragraph 38.
It starts a delegated legislation can be declared invalid by the court mainly on two grounds. First, if it violates any of the provisions of the Constitution. Secondly, if it violates the Enabling Act. If the delegate which has been given the rule-making authority exceeds the authority and make any provisions inconsistent with the Act and thus overrides it, it can be held to be a case of violating the provisions of the Enabling Act, but where the Enabling Act itself permits the ancillary and subsidiary functions of the legislature to be performed by the executive or as its delegate, the delegated legislations cannot be held to be in violation of the Enabling Act. Now, paragraph 39 also on the same line, I am just repeating. Paragraph, just you lastly can you consider paragraph 38, 39, 40, and 41. These four paragraphs deals with whether the enabling act gives me the power or not. Enabling has given me the power. 30 subsection 3 and 5. 30 subsection 3 and 5, the control order was issued, and the control order gives me the power, my lord, to issue the directives. So, my lord, I'm just not repeating all this. Now, my lord, next judgment, my lord, I just rely 2024 3 SCC 358. These two paragraphs, my lord, I just show to your lordship. First of all, my lord, paragraph 30. Paragraph 30, my lord, may I just place it? It says, my lord, it is well established principle that the statutory intervention that any authority entrusted with the function of the legislature legislates for a purpose, it can thus safely be assumed that it will not indulge in unnecessary or pointless legislation. The court has quoted the, my lord, Utkal contractors case. It says, my lord, it is again important to remember the parliament does not waste in breath unnecessarily. Just as parliament is not expected to use unnecessary expressions, the parliament is not only expected to express itself unnecessarily. Even if the parliament does not use the word without meaning something, the parliament does not legislate where there is no legislation is called for. The parliament cannot be assumed to legislate for the sake of legislation, nor it can be assumed to make the pointless legislation. Parliament does not indulge in legislation merely to state that what is unnecessary to state and to do what is already validly done. Parliament may not be assumed to legislate unnecessary. My submission before your lordship is this: the Tea Act was enacted. Now, the Tea Act, all the provisions were there. The Parliament, in his wisdom, enacting the Tea Act. Now, Tea Act provides all the provisions. Section from the very beginning, there are chapters and all these things. The Tea Act also authorize the persons to make search and seizure. Even if no delegated legislation is there, the Tea Act itself gives the power to the authorities concerned. So, the Tea Act is a self-contained act. The Tea Act authorized all the persons to act within the periphery of the Tea Act. So, Tea Act, this is a creature of the legislature, and the ideas of this Tea Act has not been challenged by my learned friend, and none of the control order has been challenged by my learned friend. So, we should go by the Tea Act as well as rules, bylaws, regulations, as well as the control order. So, considering all these aspects and considering the legislation enacted the Tea Act, the court should not interfere in such types of cases, my lord. And my lord, your lordship, my lord, kindly also take a note, my lord, paragraph 33 also. I'm not placing it, but paragraph 33 also to that effect. Now, my lord, another judgment just I will flow to your lordship. Now, my lord, the virus of the Tea Act was challenged. Now, my lord, in that virus of the Tea Act, my lord, the division bench of the Madras High Court, my lord, say, this for section 30, subsection 3, subsection 5 of section 30 was challenged, saying that excessive power has been given to the central government. So, this provision should be declared as ultra-virus. The division bench finding this is a blood inter-virus. I am not placing it, just note the paragraphs. I am just referring to paragraphs, it will be easier for your lordships. There is paragraph 8, 15, 16, 17, 18, 19, 23, 25, 26, and 27. These paragraphs deals with all the provisions of the Tea Act. I am not placing it, blood wastage of time.
And he has contended that rule 27 of the control order is ultra virus because he has sought for quashing of that.
The rule 21 in the read petition will not there is
yes, prayer A.
Yes. So, let us see the rule 27 once. You will also would get it at page 21 of the supplementary bill. It says, my lord, that suspension or cancellation of business license or permanent business license. It says the licensing authority may, after giving the holder of the business license on permanent license on an exporter or distributor an opportunity of being heard, cancel or suspend the business license on a permanent business license on any of the following grounds. Namely, it says, Lord, that that the business license or permanent license has been obtained by misrepresentations as to the material particulars. The license or permanent license has not been observed or performed to the contractual obligations to a foreign buyer or seller relating to any contract for export of tea or for import such and such. Now,
And
any
in
of
the
the
writ petition, he has said petitioner may be allowed to include the ambit of the within the ambit of the writ petition issues of ultra vires of paragraphs 7, 8, 13, 14, 21, 23, 24, 25, 26, 27, and 28.
The Milord, in the supplementary, very you also find, Milord, the blanket challenge has been made. There is no pleading to that. Milord, a legislation can be challenged, Milord, only these are the counts. Milord, you also knows, Milord, if it violates the Parent Act. If the no delegation, there is no pleading to that
there
effect.
is no ground on which it can be challenged.
No, there is one in the
No
supplementary.
ground has been mentioned in support of the challenge as to why it is ultra vires.
Yes, if your lordship will not kindly takes the supplementary review once page 4. Page 4, paragraph 3 says that in the aforesaid writ petition, petitioner has challenged the ultra vires rule 27 such and such amongst other reliefs. Now, my lord, then paragraph 27 section 30 was quoted. Then, my lord, paragraph 5 T Act reference was made. Now, paragraph kindly see, my lord, paragraph 8 that the tea distribution and export order 2005 contains several provisions, paragraph such and such, and would be ultra vires and liable to be cost and set. There must be a pleading. Somebody is challenging the vires of the act. There must be a pleading to that effect. And
vires of the control order.
The vires of the control order. This is delegated legislation. The control order is a delegated legislation. I am not disputing that. If somebody is challenging the control order, there must be a pleading to that effect.
Yes, because how will a person
Yes,
answer?
how will a person? To that effect, your lordship will not kindly consider, just I am relevant pages of one judgment, Lord. That is JK Industries Limited. Just giving relevant pages. Lord, kindly take notes, paragraph 27. Paragraph, Lord, 127, page 765.
127.
Paragraph 127. It speaks about the doctrine of ultra vires. May I just place it? It says, Lord, at the outset, we may state that on account of globalizations and socio-economic problems, including the income disparities in our economy, the power of delegations has become a constituent element of the legislative power as a whole. However, as held in the Indian Express case, the subordinate legislation does not carry the same degree of unity which is enjoyed by the statute passed by the competent legislature. The subordinate legislation may be questioned on any ground on which the plenary legislation is questioned. In addition, it may be also questioned on the ground that it does not confirm the statute under which it is made. It may be further questions on the ground that it is inconsistent with the provisions of the Act, or it is contrary to some other statute applicable on the same subject matter. Therefore, it has to be yield the plenary legislation. It can only be questions on the ground that it is manifestly arbitrary and unjust, that any inquiry into the virus must be confined to the ground on which the plenary legislation may be questioned. On the ground it is contrary to the statute under which it is made, or to the ground contrary to the statutory provisions on the ground that it is patently arbitrary, that it cannot be said to be in conformity with the statute. So, these are the grounds. What are the grounds? Nothing. So, subordinate legislation can be challenged. Look here, the subordinate legislation is in contrary to the original act. It is not. It is arbitrary. So far as arbitrary is concerned, a statute cannot be declared as null and void only because of arbitrary. Your lordship knows there are judgments to that effect. So, a subordinate legislation can be challenged. These are the grounds. I have to meet those grounds.
Then also why it is arbitrary?
Why it is arbitrary, and all these things will come. So, I just conclude my argument by saying, first of all, so far as this writ petition is concerned, writ petition, frankly speaking, the writ petition itself is not meant. He has challenged the so-cause notice, and subsequently he participated in the proceedings and participating in the verge of completion. If your lordship grants me, we will issue the order. Number one. Number two, my lord, the writ petition is based on two things. The so-cause notice was issued by an authority having no authority to so, I have said to your lordship or submitted to your lordship, it was issued by an authority having authority to issue such notice. Number 3, my lord, my land reference case is this, that notification was not gazetted. My responsible submission, it is a directives. It is not required to be published. Number 4, my lord, so far as my land reference has submitted that he has taken the clearance certificate and all these things, that these are all factual aspects. Well, I am not going into all these things. Despite that, I showed to your lordship, this certificate was issued by an authority not authorized to issue those certificates. So, only on this premises, my responsible submission would be. And if your lordship will also consider, rule 27, para 27, para 27 is also says that para 27 1E, it says the business license or permanent license.
Para 27 1 year.
Page 21 of the supplementary review. Kindly have a look. Just one. My junior is pointing out.
Page 21.
Page 21 of the supplementary review. Your lordship will not kindly see. It says, para 27 1E. It says, the business license or permanent business license has failed to licensing, has failed to comply with the directives issued by the licensing authority or any other person.
That is the show cause notice.
Yes, that is the show cause notice also. In the show cause notice also, your lordship will find. So, these are my submissions, Only one thing, so far as this show cause is concerned, my land reference has participated in the show cause notice. Hearing is concluded, but it is waiting for order as because
disposed of.
Yes.
Mr. Mehta.
Yes,
when
I continue after 2 p.m.
2 p.m. I have a fixed matter.
Sir, as any day next week, Monday, I can start.
Only
How long will
one
it take, Mr. Mehta? Shouldn't take long.
It's
only you are in reply, so
reply 40 minutes really, but I
minutes.
As your lordship give me, I require really Hajmola.
Only one page. I'll just show to you. This is the original. Kindly have a look at this one page.
Yeah.
This is the original. My land reference client is now submitting and setting the T multi-origin. This is the just have a look. The original documents keyboard. My land.
Multi-origin.
You also would find describing key as multi-origin.
Country of origin is multi.
I have also informed them that the custom authority has stopped this export consignment, not allowed, that there is no system in their system. That
Very well, we will not enter into it.
But this is
these are the facts.
When we started doing this, suppose when they comply with this, try to comply, custom authorities software won't allow this, and they stopped it. So we informed them that look, custom authorities have stopped this transaction and they have disallowed this export of cargo because you have not even communicated to the customs that the software has to be changed, because if in the body it is importantly and if country of origin.
We'll continue on the next page.
Continue. Yes.
Mr. Tiwari, learned senior advocate, appearing for
Yes.
Will you reply? Take 10 minutes.
Take shorter time.
Yes, I will take.
I have already spent a lot of time on this.
No, I will take very short.
Because you are in reply only on law.
Yes. I will very short.
Thank you.
My lords, can I make a mention? Court Master sir. Yes.
Before I start, if Dr. Shah has to add something, he can.
Yeah, maybe I will add just one small thing from their submission, because that day the Shalini, they gave that judgment, Supreme Court, which is the only judgment they relied. Now, my lord, if you kindly have that judgment, paragraph 49. Actually, after reading this, I thought I should have given this, because paragraph 49C, that's only, I will only rely on that small part.
49C.
Yes. Your Honor got that? So, high courts cannot, at the drop of a hat, in exercise of its power of superintendence under Article 227 of the Constitution, interfere with the orders of tribunals or courts inferior to it, nor can it, in exercise of this power, act as a court of appeal over the orders of the court or tribunal subordinate. My lord, we are here exactly the tribunal order. Against that we have come,
But not as
NCDRC.
an appeal.
Not
because appeal is not provided for.
Right,
So
not in the true sense, it's a writ, but under 227 we could not have come.
No, sir. The same thing will apply to 226 also. At the drop of the hat, 226 also is overruled. Because the same principles apply when you are exercising certiorari jurisdiction as well as 227 jurisdiction, with the difference of, again, when it is against a government authority and it is to keep the bounds of, keep this subordinate tribunal or court within the bounds of their jurisdiction.
Those observations are in this one also, because but they are also, and I may show you, your lordship have gone through, this case emerged from a tenant and owner dispute. And Supreme Court, not this, I have gone through, repeatedly said on property dispute, there we see that these writ petitions are filed, but medical negligence, now where we are here, it is a completely different pedestal, because there is also Article 21, right to life, because in medical negligence, a patient goes to a doctor, he has a right to life. Everybody, not just any citizen, even foreign citizens, they have that. Now, if the doctor uses wrong medicine and harms or kills the patient, that is violation of his fundamental right, and that will be under 226 only. So, my lord, and then you see the original 226, there are two clauses, 1 and 2. So, doctrine of situs and doctrine of cause of action for 226, 1 and 2. So, but for 227, there is no parallel to that cause of action thing. But even if we go there, it is 227, we can only go to doctrine of situs, meaning in Delhi, because this is by NCDRC. But with 226, 1 situs, the same thing, we could go Delhi, but cause of action, that is only here. This case, the cause of action in Calcutta, but we have come here against the Delhi order.
Mr. Dr. Saha, I have gone through the Rajasthan judgment.
Yes.
It is not correct in the on the proposition of law of what that it has sought to elaborate. When a tribunal is such that it exercises jurisdiction over several other subordinate tribunals stretched out throughout India or spread over throughout India, then each jurisdictional high court will have, each high court having jurisdiction over the subordinate tribunal will also have jurisdiction over the main tribunal. For example, suppose there is a debts recovery appellate tribunal. Now, the debts recovery appellate tribunal is situated in Calcutta.
Mm-hmm.
Now, this debts recovery appellate tribunal has supervisory jurisdiction over several debts recovery tribunals subordinate to it, which are there in, say, Allahabad, which are there in Hyderabad, and debts recovery tribunal in Kolkata. So, if an order which is appealed against before the District Recovery Appellate Tribunal in Kolkata has originally been passed by the DRT Allahabad or DIT Hyderabad, then this court will not entertain a 227 application against the DRAT's order, saying merely because DRAT is within the territorial jurisdiction of this High Court.
Right.
Because it is having jurisdiction over several other subordinate tribunals to which it is appellate.
Yes, yes.
So this has not been considered by the Rajasthan High Court, subject to what
Yes,
Mr.
but-
Das will say. But
okay.
this is my understanding of the law.
Your Lordship is
I have-
Okay, my lord, even if I agree with what you just said, now 227 is applicable, we can use. But nowhere, this judgment, all the one I have given, it says, it doesn't say 226 is not applicable.
No,
You can-
Shalini Shyam Shetty, the
Yes.
paragraph which was pointed out, paragraph 51.
Yes.
51 is the problem. 226 maintainability is becoming a problem because of this.
No
51.
common intelligence.
Page 51. If you paragraph 51, sorry.
Paragraph 51, yes.
If you see fifth sentence, all the respondents in a writ petition cannot be private parties. Now, this was the point which was taken by them. Here, all the respondents are private parties. If all the respondents are private parties, then a writ cannot be maintained. That is what you have to, then if you have made private parties, then the next, but private parties acting in collusion with state respondents
Yeah,
can be respondents to the writ
different.
petition.
That's different.
All the respondents,
Yes.
if they are private parties, this is the problem which is being
But
created.
my lord, 227, even this judge assured your lordship, doctrine of sitters, how it is maintainable
No,
here.
in a National Consumer Disputes Redressal Forum, in my research, I have found a judgment
have also
of
found
the
out.
Supreme Court
Yes.
itself, which says that it should be filed in Calcutta. 227. 227 was carried to Delhi.
That one I didn't see. But even then, my lord,
I think
I
it
have
is,
given you the latest Supreme Court there.
This is also, I think, of 2025 or 2024.
Siddhartha is Mukherjee's case.
Siddhartha
Yes,
Mukherjee.
Mukherjee. Not I brought
I
that
think-
Oh,
judgment.
yeah. I remember.
But
I have
kindly
seen it.
seize
I have
this
seen it.
judgment at for once. But
Yeah.
make paragraph 4 onwards. The present
Can
appeals
give
have
a
been.
copy to Dr. Saha
Lordship,
also,
I shall,
because he may
I
not
shall.
have it.
No, I have read that. But I can, I will appreciate if you have a copy.
But I have a copy.
Because Universal Sompo was considered, and the matter was sent back to
Yes.
Calcutta High Court under Article 227.
Yes.
Can you see?
Number
Paragraph 4.
Paragraph 4. The present appeals have been filed by the appellants being agreed by the order dated 4th October 23, passed by the learned single judge of the High Court on Delhi on petitions filed by the respondent number 1 under Article 227 of the Constitution of India, assailing the common judgment and order dated 26th August 2022, passed by the NCDRC New Delhi in two revision petitions, one filed by the appellants herein and the other filed by the respondent number 2 herein. The grievance of the appellants is that the High Court of Delhi ought not have entertained the petition filed by the respondent number 1 under Article 227 of the Constitution of India, as it cannot be treated as a jurisdictional High Court in the instant case, as has been referred in Messrs. Universal Sompo General Insurance versus Suresh Chand Jain and other. He submits that the entire cause of action of the instant case has arisen in Kolkata. The respondent number 1 filed complaint against the appellants and the respondent number 2 before the District Consumer Disputes Redressal Forum Unit 1 at Kolkata, which was rejected by order dated 13th October 17. Aggrieved thereby, the respondent number 1 had filed an appeal before the State Consumer Disputes Redressal Commission West Bengal at Kolkata, which was allowed by order dated such and such. Dissatisfied by the said order, the appellants herein and the respondent number 2 hospital have filed review petitions before the NCDRC that were allowed. Initially, the respondent number 1 had filed petitions for special leave to appeal before this court, challenging the order dated 26th August 2022 passed by SCDRC. However, in view of the judgment of this court in Universal Sompo Supra, liberty was granted to him to approach the jurisdictional High Court. Treating the High Court of Delhi as the jurisdictional High Court, the respondent number 1 has filed petitions under Article 227 of the Constitution of India. Notice was issued on the said petitions on 4th October 23 on the adjudication of the jurisdictional aspect. This has what brought the appellants before this court. Learned counsel for the respondent number 1 contains that the jurisdictional court in the instant case ought to be treated as the High Court of Delhi, inasmuch as the judgment impugned before the High Court was passed by NCDRC at Delhi. In our opinion, that can hardly be treated as a ground to invoke the jurisdiction of the High Court of Delhi. The respondent number 1 ought to have approached the High Court of Calcutta, being aggrieved by this impugned judgment as the entire cause of action in the present cases arisen in Kolkata, where the patient was operated for ovarian cancer on 24th February 2012 and expired on 30th July 2014. The complaint case was filed at Kolkata based on the aforesaid cause of action, merely because NCDRC has allowed the revision petitions filed by the appellants, and the respondent number 2 would not be a ground to waste jurisdiction in the High Court of Delhi.
And
my lord,
this revision is being entertained by the High Court.
Yes. Okay. Even if I agree with this view, nowhere it impugns that you are barred from filing 226. In fact,
227 is because of the private respondents only being party. There is no statement.
no, that's okay. That is okay.
That is the
if I
only
agree,
problem.
but
Otherwise, it is not barred. Even I am saying it is not barred. But in view of paragraph 51 of Shalini Shyam Shetty,
yes,
when two remedies
yeah,
are there,
I see.
226 and 227, and Shalini Shyam Shetty says all private respondents, only private parties cannot be respondents. Then in that case, it will be.
But then my lord, the Supreme Court 2025, this latest one, the PGI, but says there it only says that we direct the petitioner to go and file that one on the first page. I gave you the 2025. Please. You want to got that? That's dated 8/1. Yes, you have referred this. The appropriate course for the petitioner is to invoke the writ jurisdiction of the High Court under Article 226.
Dr. Saha, there were several parties. Whether one of these were government parties or not, I don't know. Because this by itself is not the ratio. This is only a direction. See, I'll be bound by the ratio, whatever Supreme Court lays down. Shalini Shyam Shetty is the ratio. It says it cannot happen. It cannot happen. Here, there are several other parties. Devendra Kumar Sharma is one. Several other parties are there.
They are private
those
parties.
Are government
I
parties
can
or
get
not,
that.
I don't know.
They are private parties, not government parties. Besides, here they are not saying you can also file under 227.
But
so there is a dichotomy.
But Universal Sompo says 226, 227.
Yes. Yes.
And there is one more thing, Dr. Saha.
Ibrat Fazan. I have also got it.
No, both the Ibrahim Fazan, I know. Yes.
Now Dr. Saha, there is one more thing. Law is that if you will be bound by such judgment of the Supreme Court, if it is earlier in point of time, it has not been taken into consideration by the later judgment, the earlier judgment will be binding.
My lord, that means you have to pass an order that you cannot file in 226, challenge this thing.
If there are only private parties.
If there are only private parties.
Yes.
But if I add, this is against a statutory body, NCDRC.
No, but
and in fact, many of them
is not before me.
No, I can make them a party. In fact, number of cases I have gone through, they have made NCDRC a party.
Yes, that you can do always.
So we can do that in the course of the trial. I can add for the sake.
Yes, of course. If you seek liberty, I'll definitely grant you liberty to add immediately.
Yes. So I will do that then, my lord.
Do that.
Then. No. There have been number of judgments.
By itself is a tribunal.
But commission by itself, adding as a party, writs have been entertained and are maintained.
Yes, number of them
are entertained and have been entertained. If he adds as a commission as a party, I cannot stop him. Today, if he makes a prayer that I want to add the commission as a party, can I stop him? He is the dominus litis. How will you stop him? From we cannot stop him from adding the National Consumer Disputes.
And then there are number of writs they have added NCDRC.
Today, suppose he had filed the writ petition with NCDRC as a party, what would you have done? This point would have gone immediately.
Yes.
The point which you are taking that all parties are private, this point would not have been available only.
I will do that, my lord. The only issue is, of course, a time factor, because I have to do.
Or you can do this, you can file a 227, it will again be before the same honorable court.
No, my lord, that will be more time factor, because it will be again new time, new bench. So, my lord, I don't want to do that. So, my lord, my humble prayer is, at least if you don't accept that, okay, I have to add a party, government party, and
No,
let me
in
do.
view of this,
Yeah.
Salim Syam Sethi, I will record that you are praying to
Lordship
add,
kindly
Yes.
considers Ibrat Faizan once.
Hey, Ibrahim Faizan is, I'm very well aware, yes. They are also, it's pretty much same as Sompo. There's nothing new.
But Ibrat Faizan says it should be a petition under Article 227. Because my lord,
I am appearing for the respondent number 1, my lord. And according to the position of this case, my lord, the only available remedy is under Article 227. 226 does not lie in this case, my lord, only because of the reason there is a marked difference between the provisions contained in 226 and 227. Under Article 226, my lord, it has to be established that some rights of the individuals as citizens of India has been infringed. And it may be the constitutional right, it may be the fundamental right, it may be the statutory right. But under Article 227, my lord, there is a marked difference.
But
that
NCTS kindly sees Ibrat Faizan once, kindly sees paragraph 18 of Ibrat Faizan.
My lord, I have said it.
Whether the
Please
National
wait, sir.
Commission.
Somebody is making submission, let him complete, then you make.
My lord, in Ibrahim Faizan case, it has been
Sir, please wait.
categorically.
Somebody is already making submissions. He is appearing in person. Please
My
wait.
lord, my lord.
Yes, Mr. Das.
Number kindly comes to paragraph 17 onwards.
17.
It is not in dispute that in the present case, the appeal before the National Commission was against an order passed by the State Commission under Section 47(1)(a) of the 2019 Act. Therefore, against the order passed by the State Commission passed in a complaint in exercise of its powers conferred under Section 47(1)(a) of the 2019 Act, an appeal to the National Commission was maintainable, as provided under Section 58(1)(a)(2)(3) of the 2019 Act. But thereafter, Section 67 has been discussed. Kindly comes to the concluding portion of that paragraph. In that view of the matter, the remedy which may be available to the aggrieved party against the order passed by the National Commission in an appeal under Section 58(1)(a)(3) or Section 58(1)(a)(4) would be to approach the High Court concerned having jurisdiction under Article 227. Now, that kindly comes to the next paragraph. Whether the National Commission can be said to be a tribunal for the purpose of exercise of powers under Article 227 of the Constitution of India by the High Court is concerned has been considered by the Constitution Bench of this court in Associated Cement Companies, which is required to be referred to. In paragraphs 44 and 45, it is observed and held as under. An authority other than a court may be vested by a statute with the judicial power in widely different circumstances, which would be impossible and indeed inadvisable to attempt to define exhaustively. The proper thing to examine each case that arises and to ascertain whether the powers vested in an authority can be truly described as judicial functions or judicial powers of the state. For the purpose of this case, it is sufficient to say that any outside authority empowered by the state to determine conclusively the rights of two or more contending parties with regard to any matter in controversy between them satisfies the test of an authority vested with the judicial powers of the state and may be regarded as a tribunal within the meaning of Article 136. Such a power of adjudication implies that the authority must act judicially and must determine the dispute by ascertainment of the relevant facts on the materials before it by an application of relevant law to those facts. The test of the tribunal is not meant to be exhaustive, and it may be that other bodies not satisfying this test are also tribunals. In order to be a tribunal, it is essential that the power of adjudication must be derived from a statute or a statutory rule. An authority or body having power of adjudication from an agreement of the party, such as private arbitrator or a tribunal, acting under Section 10A of the Industrial Disputes Act does not satisfy the test of a tribunal within Article 136. It matters little that such a body or authority is vested with the trappings of a court. The Arbitration Act 1940 vests an arbitrator with some trappings of the court, so as also the Industrial Disputes Act 1947 vests an authority under Section 10A of the Act with many of such trappings, and yet such bodies and authorities are not tribunals. The word tribunal finds place in Article 227 of the Constitution. Also, I think that there is there also the word has the same meaning in Article 136. Therefore, National Commission can be said to be a tribunal which is vested by a statute with the powers to determine conclusively the rights of two or more contending parties with regard to any matter of controversy between them. Therefore, as observed herein above in the aforesaid decision, it satisfies the test of an authority vested within the judicial powers of the state, and therefore may be regarded as a tribunal within the meaning of Article 227 or 136 of the Constitution. Also, in a given case, this court may not exercise its power under Article 136 of the Constitution in view of the remedy which may be available before it to the aggrieved party before the High Court concerned under Article 227 of the Constitution, as it is appropriate that the aggrieved party approaches the High Court concerned by way of filing a writ petition under Article 227. So, my lord, the NCDRC in terms of Ibrat Faizan is a tribunal. So, my lord,
that it is. There is no
my lord,
doubt
whether the tribunal which has passed the order, my lord, whether the tribunal by itself can be made a party, my lord, in a pending writ petition.
It is not
Because,
a
my lord, it's
necessary
not the
party. It is
tribunal which is
definitely
under
not.
challenge.
It is
It's
not
the
a
order of the
necessary.
tribunal which
It is not a necessary party because a tribunal is not required to defend its own order. Therefore, it is not a necessary party. But it is not unusual seeing tribunals being added as parties. All the writ petitions that come up to this court against DRAT's orders.
But we do not make the DRAT as a party.
Writ
But
petitions you have to make, otherwise
banks as a party,
writ
or
petitions,
whether the guarantors or
if it is a private bank, Axis Bank,
But
HDFC
Axis
Bank.
But my lord, we are
in that case, a writ petition will not be maintainable. DRAT is made a party. That is what I have seen.
My lord, perhaps my lord,
opposing
my
the
lord,
petitions.
But courts do not appreciate, my lord. It's more or less like, my lord, a learned single judge, we prefer an appeal, we make the learned single judge as a party in that appeal. My lord, whether that
I have number of judgments here. I will show you. NCDRC exactly under SOMPO, this thing has been made a party. Not in all. That's why I didn't give it, to make more confusion. Second of all, NCDRC was not a party in the Ibrat Faizan. Third of all, SOMPO was a follow-up observation of Supreme Court, where categorically they say 226, 227. So what they are submitting, because this was saying only 227, that only 227, they never said 226 is excluded. In fact, follow-up SOMPO says 226 categorically, 226 or 227, my lord, giving the option to the petitioner, appropriate situation. So, my lord, this argument that Ibrahim Faizat said 227, where no government was there, NCDRC was not a party. So they said that means that's the law. No, that is a misinterpretation of the actual position of law. So, my lord, and then especially this latest one, I said only they didn't say 227. As your lordship said, maybe there was a government authority there, maybe not. But point is, even then, they could have said 227 also. That government doesn't bar to go under 227. So it would be wrong interpretation that no, you have to do under 227 and you cannot make NCDRC party. No, my lord, I will show you judgment, number of them. NCDRC has been made a party.
But even if NCDRC is added as a party, NCDRC will have nothing to say in the proceeding. NCDRC will not come to defend its order because it's sort of a judicial body.
No, but
it is not going to come and defend its order. We are making parties people only if we find that the party concerned will be affected by the order that is going to be passed by this
No,
court.
my lord, if we then go a little bit in the merit of the actual writ that I filed, there are glaring apparent error on the face of that judgment by NCDRC. And maybe if NCDRC is a party, they will understand that it was a mistake to make that apparent error. If I may show you, my lord, in the original petition that I have filed, actual order.
My lord, every honorable
My lord,
judge, my lord, has the right,
my
my
lord,
lord, to pass a correct judgment has the right to pass a wrong judgment. It is the judgment which is under question.
But
It is
NCDFC
not
as a
the
party may
concern,
have a
my lord,
different opinion. May have,
my
I
lord,
mean,
judicial
I can
officer, my lord, who has to
speculate.
be made a party.
Why should we speculate now?
It's
What
not a
NCDFC would be
speculation,
doing?
Shah.
One thing is, are the necessary party? I would say yes. Under this situation, they are necessary party because they may change their own order appearing here before your lordship. Once they come to see, this is a apparent glaring mistake on their part. It's not unimaginable, my lord. At least you cannot deny my right to make them a party and hear it right here, 226. And after that, after judging, looking into the merit, everything, then your lordship can dismiss this on this ground. No, it can be done 226, just on this ground. But then you have to hear me. You have to see what wrong was done and how absolutely patent error on the face of the judgment.
But patent error in passing a judgment will not make the judge liable. Because
No, I'm not saying judge liable, but they
so
may
he is not supposed to
they
defend the
may come and admit that. They may. I'm not saying they will. But my lord, you cannot at this stage of inception cannot take that right from me, my lord. That's all I'm submitting. So you kindly allow me under this thing. My interpretation that it clearly
Very
can
well.
be.
Let us allow.
May I say this?
Mr. Das, please wait. If he adds NCDRC as a party, you will always have the option to say that NCDRC as a party has been added only for the purpose of maintaining this writ petition under Article 226.
I was thinking of something else. My argument before your lordships would be that whether, based on a presumption that if the NCDRC
Mr. Das, if he had filed the writ petition originally with NCDRC as a party, would you have had any say? So you would have raised this objection if NCDRC were the party. If it is added as a party, then also you can raise this objection.
Very well,
What is the problem in that?
We'll
Let
raise
him
this
proceed upon adding it as a party. You will always have the
let him add the
chance
NCDRC
to,
as a
because
party,
you
we'll
are
argue on
shutting
that
off.
point
Then in that case, you make an application for adding NCDRC as a party, stating why you want to add it.
Yes.
You
That
need
will
an
be rather
application.
better.
Okay. I will do that.
Because then in that case, whatever you want to say will be on paper. They will have an opportunity to oppose it instead of having that oral battle.
Yes. Fine. I will do that, my lord. Just give me 2 days, 3 days. Friday.
Passing any order, you make an application. This matter is pending.
Okay.
Application, because I will not grant you leave to file an application. You file an application that you want to seek add NCDRC as a party.
Okay. I'll file.
That would do.
And then can it be taken up Friday then?
No, this Friday won't be possible because Fridays I will.
I
have
am
other
my
matters.
only problem is this. But then my lord, how soon, how quickly it can be taken, my lord? Monday maybe?
No, it will go to next Friday, 12th.
Next Friday?
12th.
Just on that application.
Yes.
So do I file an IA?
Yes, I is can.
IA should be appropriate in this kind of situation. I can give IA or can, yes. In this kind of situation, I can make my argument in writing, and your lordship, even after this, want to dismiss it without hearing the merit of the case, your lordship can do that, of course.
But if he files a can, let him file again, because we would be using an opposition to that can. Because we have to raise our points as to why we are opposing. If he at all files the application, that how can he make NCDRC a party to a writ petition in order to maintain the writ petition? But we would be
now the question is he has allegations against NCDRC. That is
that is nowhere in. He is questioning. What he is saying is that the order which has been passed by the NCDRC, he is challenging the judicial propriety of that order. But he is not making any individual allegations against the honorable members of the NCDRC or the staff of the NCDRC.
If there was an allegation against a member of the NCDRC, then also NCDRC was not
a necessary party.
Then the member would have been a
necessary party,
not the NCDRC.
So, in that case, what he is actually trying to say is, he presumes that the order which has been passed by NCDRC, that's a wrong order. My lord, he
Of
says that
course,
I
that's why I've come here.
understand.
That's
Dr. Sir, I
yes.
understand. Now, my lord, what he, my lord, if that is so, my lord, indirectly he is questioning the judicial propriety of that order. So, my lord, whether if he
Not
questions
indirectly, directly. That is in
directly, my lord, he is
This is
questioning the
enforcement of
judicial
that order.
propriety of that order. So, my lord, if he questions the judicial propriety of that order, my lord, before entering into the merits, my lord, he first has to show that even by adding NCDRC as a party to this writ petition, his writ petition becomes maintainable. My lord, first he has to overcome that hurdle.
Without adding NCDRC as a party, prima facie it does not appear that the writ is maintainable. I can release it then in that case because I don't have jurisdiction for 227. I will observe this, release this,
My
so that
lord.
it goes before the Honorable Chief
No, my lord,
Justice for being
then
assigned.
this would have been done 2 weeks ago, my lord. But
Yes,
my lord,
now because
since
the arguments
I'm
have to be
waiting,
heard.
my lord, okay, here's another submission, just prayer. Give me a leave to make amendment on the memo of parties. So I will change. That is always done many times by in many rates. Just give me a leave to change memo of parties. That's my choice. Court cannot bar me from making somebody a party or not. If it is for any reason, you can always.
But I apprehended that Dr. Shah would be making this argument. Now, I am putting a question to myself. Well, let us consider a situation in which a plaint is filed by a application before the Deaths Recovery Tribunal has been filed by A as against B, C, and D. Now, when he enters into the High Court, now, for challenging that order by BFN article under application under article 226 or 227, can a new person E be incorporated into it?
But my lord, you have to think, why are they vehemently opposing? They are not saying I cannot file this appeal. They are saying file 227. What is the difference?
If he files an application under 227.
No, okay. Even if I accept that, but I have a choice, and there's so many cases. I cite it's 226, 227, 226, 227.
226, 227 is not in Calcutta High Court, not rules don't permit. 226, 227 are not interchangeable because, as I said on the last occasion, the determinations lie with different honorable judges. If the same judge had both the, for example, if I was exercising 226, 227, this argument, I would have brushed aside saying very good. I also have 227. I'm exercising the jurisdiction of 227.
But now that, my lord, it has gone, so give me that leave. I mean, that you cannot take away from me to make a change in the memo of parties for the ends of justice.
But my
In my view, the complainant's view, for the ends of justice.
Which allows him to make a change in the memorandum of parties. This is an order, my lord, order of affirmation, my lord, passed by 3 commissions in which that particular authority was two authorities, my lord, in which that particular
affirmation by one, original order by one.
Yes. So, my lord, when it comes back, my lord, whether a change in the area of parties can be made. But if let us consider a plaint. A plaint, it comes up in
Plaint is civil proceeding. Don't equate it with a civil court. That is absolutely different because.
But incorporating someone who was not a party to the original proceeding, but whether that is permissible.
It is permissible. I will provide annexures and documents, supporting documents.
Whether incorporation of a statutory authority in the as a party to the writ petition just in order to hold the writ petition maintainable, whether that is permissible.
No. It is permissible. It has happened many times, and I will provide those as supporting evidence that NCDRC has been a party. Every case, same thing. They pass a judgment. We come under writ, under the SOMPO, the new.
So let us argue this out.
Yes.
You argue.
But my submission is, two wrongs, cannot make a right. If someone has added a party wrongly, that cannot confer a right upon me that I will, NCDRC in that writ petition.
If he can satisfy that NCDRC is a necessary party, then in that case, definitely NCDRC has to be added. So he has to satisfy that.
My lord.
Dr. Shah, would you be able to satisfy today, or do I keep it on the next day? I'll record this.
Let me show your lordship. No, today itself. Because I'm ready for the appeal. I mean, for the original writ to argue.
But only on the point of, not on the merits of the matter.
Why NCDRC is a necessary party?
My lord, because as I said, for one, there is such a
We'll have only 10 more minutes today because I'll have a division bench at 3. So I'll rise at 2:45.
My lord, then take it next day because it may take a little longer than that. So, can
Court 19, yes.
can I?
But I
Yes,
also
sir.
will be appearing before your lords.
There are several assigned matters before the division bench.
My lord, then a quick date any day, my lord. Just time. I mean, I will greatly appreciate if you can give it this week, anytime.
We can have it on 12th then. 12th.
12th.
12th is next Friday, Friday week. After
Yeah.
this Friday.
Is it possible before that, my lord? Because you know, I have
Before
to
that
go
will
back.
be difficult because this matter takes time and all other matters are held up. We are approaching vacation. So there are other matters with pressing urgency. Somebody is suffering demolition. Somebody's job is to be terminated. This is a case of compensation. So whatever
lord,
time
it's a
you take.
medical negligence case, my lord.
Yes,
So
yes.
it is a
But
different
here
thing than a tenant and landlord.
no. Here the only remedy that you have is ultimately compensation. Compensatory remedy is the only remedy. So urgency in that sense is not as great as the urgency in somebody's house being pulled down.
But my lord,
or somebody's
on
bank
the,
account
on the
being
point
attached.
of medical negligence,
Yes,
my
that's
lord, it's
there.
a different footing
That's there.
than all these things. So, my lord,
12th.
Fine, 12th. I will be 12th.
लिखे नहीं
So,
Mr. Das, learned advocate appearing for the respondent, relies on a judgment of the Honorable Supreme Court in the case of A. Siddhartha Mukherjee and another versus Madhav Chand Mitter and another, within bracket is civil appeal number এগুলো দিয়ে দেবে না সিভিল অ্যাপিল নাম্বারটা দিয়ে দেবে হ্যাঁ এখানে 1 লিখলাম না কারণ অনেকগুলো আছে এইটা দেখে নেব to submit that an application under Article 227 of the Constitution of India is very well maintainable before this court against the order of the National Consumer Disputes Redressal Commission, and that in such view of the matter, the judgment rendered by the Honorable High Court of Rajasthan in the case of Rajiv Chaturvedi versus Commissioner, Jaipur Development Authority and another, within brackets 2024 SCC Online Raj 365 cannot be said to be laying down good law. Full stop. Paragraph. He also relies on a judgment of the Honorable Supreme Court in the case of Ibrat Faizan, IBRAT FAIZAN versus Omax, OMAXC, Omax, Build Home, BUILD HOME, Home, Private Limited, reported at 2023 11 SCC 594, and submits that in the said case, the Honorable Supreme Court had held that you relied on paragraph
18. But 18, my lord,
that since National Consumer Disputes Redressal Commission ওই এক জায়গায় NCDRC উপরে লিখে দিলে ওটা কপি হয়ে যাবে NCDRC is a tribunal, therefore the proper remedy for an aggrieved party for a party aggrieved by an order passed by the NCDRC in an appeal under section 58 within bracket 1 within bracket small a within bracket III or section 58 within bracket 1 within bracket a within bracket IV of the Consumer Protection Act 2019 would be to approach the High Court concerned having jurisdiction under Article 227 of the Constitution of India. Full stop. Paragraph. Dr. Saha, learned Dr. Saha appearing in person, appearing representing the petitioners. Dr. Saha representing persona, he is an agent. Dr. Saha representing the petitioners submits that he has good grounds to add NCDRC as a party to the petition, and as such, this petition should be entertained as one under Article 226 of the Constitution of India. Full stop. He seeks leave of the court to add NCDRC as a party to the writ petition. Full stop. Such request of Dr. Saha is opposed by the learned advocates appearing for the respondents. Full stop. Dr. Saha therefore seeks time to demonstrate how NCDRC is a necessary party and should be added to the petition so that this petition can be entertained as one under Article 226 of the Constitution of India. Full stop. As prayed for, list this matter once again on December 12, 2025 at what, 2 p.m.?
2 p.m.
2 p.m. At 2 p.m. so that other matters can be taken up, because we are just nearing vacation, 1 week's vacation, but still.
Yes. Grateful, my lord.
Yes, we had made that prayer. I'll be taking up hearing matters in a while. You see how the court is functioning. It's very difficult for hearing matters. Some hearing matters have been mentioned. I'll designate 1 or 2 days when I'll be taking up only hearing matters. Yes. Once it is started, it will not take its course. I will have to follow the course. That's it, Dr. Shah. কল করুন, কিছুক্ষণ হবে, 5 মিনিট হবে কিছু না, অরিজিনাল সাইড লেখা আছে না, অরিজিনাল সাইড করুন।
Your Lordship, is it a good time to mention a case?
Yes.
So my case is appearing in the list, item number 28.
Appellate side or original side?
Original side.
Yes, item number?
Item number 28.
28?
Yes, sir.
My lord, I appear for the respondent in the matter. My lord, this item number 27, my lord, which my friend is mentioning, my lord.
Yeah, 27, sorry.
Item number 28, what happened?
So, we have been evicted from our factory by Shama Prasad Mukherjee Port in an illegal way. They have also offered our material for public auction. The auction is already complete and the buyer has...
There in the list, it will be taken up in due course.
Sir, it's very urgent. Only the delivery is due. The buyer who has taken the material in auction, he has already done the payment. Only the delivery is due. So, sir, your interference is very important.
You are appearing in person?
In person, sir.
My lord, this item number 27, my lord, I'm appearing for the respondent, my lord. I received a mentioning notice at 2:20, my lord.
27 or 28? He's mentioning 28.
My lord, 27, my lord, he's mentioning.
27.
My lord, yesterday, my lord, a 4-volume supplementary affidavit has also been handed over.
4-volume supplementary affidavit?
Yes,
you
my
have been granted leave by court to use a supplementary affidavit?
No, my lord, not till now, my lord.
Very well, we shall upgrade it on any day, not tomorrow. You please keep a watch on the list.
My lord, if possible on a Friday, my lord, two days, my lord, I'm not in Calcutta, my lord. I'll request if it's on a Friday, my lord.
Very well.
My lord, may take it up on Friday.
Fridays to will be a different day. ঠিক আছে, Friday তো আমরা ইয়ে নি না, इसलिए assign নি না। একটা কাজ করবেন, Thursday you are not here.
My lord, tomorrow and Thursday, my lord, I'm not there, my lord.
So can you fix a date so that it will be easier?
My lords,
for
I
us?
can, my lords, I'll have to, if I can, if my lord will permit me to appear through VC, my lords, I'll be able to do it, my lords,
VC,
but
I have no problem, but the problem will be with the network. If there is a network issue,
my
it
lords,
will
because
be a
I'll
base
not be,
complaint.
yes, my lords, because I'll not have a fixed, my lords,
Many
place.
times the screen is frozen, voice is not heard, everybody
My lords,
becomes.
then on Friday, if it is permissible, but my lords may fix a time as per the convenience
Friday
there.
will have specially assigned matters that becomes difficult to take. একটা কাজ করি তাহলে এইটা থার্সডে আমরা পাবলিক প্রেমিসেস আনঅথরাইজড অকুপেন্টস অ্যাক্ট নিই না থার্সডে অরিজিনাল সাইডে থার্সডে এটা উপরে তুলে দিই পাবলিক প্রেমিসেস আনঅথরাইজড অকুপেন্টস অ্যাক্ট ইট ইজ আন্ডার দি পাবলিক প্রেমিসেস আনঅথরাইজড অকুপেন্টস অ্যাক্ট
Yes, sir.
Yes, my lords, yes.
so let this appear on Thursday পাবলিক প্রেমিসেস আনঅথরাইজড অকুপেন্টস অ্যাক্টের হেডিং এ দিয়ে এটা উপরে দিয়ে হ্যাঁ on Thursday week
Very well, my lords.
Thursday week means 11th
11, my lords, very well.
Thank you, sir.
Obliged.
একটা কল করুন না দেখা যাক
Item number 2.
only to say not today.
She is engaged in another courtroom, my lords.
I expected that. 2 and 3 both gone.
Item number 4.
Do you have any information? Appeal has been filed or not? No.
No, my lord.
Against the Sestat order?
Against the Sestat order by the petitioner? No.
No.
By respondent?
Yes, because the
They have they have filed a SL. They have filed an appeal before the Honorable Supreme Court.
Directly.
No, it's not actually, my lords, it's a valuation matter. So valuation and classification matters directly appealable to Supreme Court, not High Court. That's as per section of the Customs Act. That they have gone there and it is pending, my lords, the status.
Yes.
For the petition, my lord, yesterday, my lord had been pleased to fix one matter up, which is a connected matter on the 9th of December. I was requesting kindly have this matter on any week thereafter. My lord, on 18th
as prayed for by the learned advocate appearing for the petitioner, list this matter on
18th or 19th of December.
On 18 December 18.
Right. So very great.
Yes. 5.
For the petitioner. Your Lordship, Mr. Bhattacharjee is appearing. Yesterday also he was not there.
Not today then, because today it's hardly time. হ্যাঁ ঠিক আছে আর একটা কল করুন দেখে নিচ্ছি
Item number 6.
I'm appearing for the petition. I have finished, Your Lordship. This is that matter. GST penalty was levied where no show cause notice we have not received.
Very well, I remember it. Next day I'll have a division bench.
Yes, yes.
Thank you.